We're on the record. It is 9:07 a.m., Monday, October 4th, 2021. Counsel, please put your appearance on record.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
All right, we're going to start with, oh, I don't have that on my list. Okay, we're starting with Portuguese. Yeah, but I mean, I was looking for that, but it's on your list. So I call in here. Is that what I do? Okay.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
We're looking for the Portuguese interpreter.
All right, Your Honor, I'll go ahead and let my office know that you're awaiting for them and let them, have them connect, Your Honor. Thank you.
All right, they were supposed to be, so I don't know if, I don't know. I'll reconnect.
Yes, Your Honor.
Thank you. Let's try that again. Maybe it's video conference, not interpreter.
Welcome to an Econo meeting. You are entering the meeting now.
No. Good morning, this is Judge Gibson. Can you hear me?
Yes, I can hear you, Your Honor. Can you hear me? This is Paulo Lara, Portuguese interpreter.
Yes, I can hear you, but I don't see you.
Good morning, Your Honor. I'm Jonathan Witt. I can hear you as well.
Which case are you here on, Mr. Witt?
Your Honor, I'm here for Dorsicora Freeman, which is 21 CF 11732.
All right, it's going to be a while before we can get to that case.
Yes, ma'am.
So just hang out. I won't disconnect at this point, but I can't tell you when we'll get to you. Just let me get through some interpreter cases.
Not a problem.
Ms. Freeman is an ROR motion.
Okay, we can do that after all the move-ups. So let me get to first the Portuguese interpreter.
Your Honor, I have not been sworn yet today, and I have the case 2021 CF 13088, an initial appearance.
I have 13077.
077. I'll confirm with the office, but this is for William José da Silva.
Hold on, I have them in the wrong order.
No problem.
It's gonna be a Monday, y'all.
No problem.
All right, so who is this? All right, please raise your right hand to be sworn.
Do you swear to interpret from Portuguese to English, English to Portuguese, testimonies you will receive today?
Yes, I do. Paulo Lara, Portuguese interpreter.
All right, good morning, sir. Please tell me your name.
Bom dia, senhor. Por favor, diga o seu nome.
William José da Silva.
William José da Silva.
21 CF 13088. You're here charged with aggravated assault, domestic violence, and battery domestic violence.
Senhor, o senhor está aqui no caso 2021 CF 13088AO sobre acusação de violência doméstica e agressão e violência doméstica.
At this time, I'll appoint an attorney to represent you.
Neste momento, eu vou nomear um advogado para te representar.
There is probable cause here.
Tem causa provável aqui.
Does either party wish to be heard on bond?
Alguma das partes deseja dizer alguma coisa com relação à fiança?
Your Honor, state we just asked that you set a reasonable bond. I don't see that he qualifies for PTR. Also, due to having an immigration container, I don't know his ties to the community, so state we just ask for a reasonable bond on both counts.
Meritíssimo, nós gostaríamos de pedir para uma fiança razoável, porque neste momento ele não tem PTR e também ele não tem nenhuma relação com a questão da imigração, então nós gostaríamos de pedir que seja razoável a fiança.
Your Honor, I just actually taking the count, he has no criminal history.
Meritíssimo, gostaríamos que você levasse em consideração que ele não tem antecedentes criminais.
All right, thank you both.
Ok, obrigado a ambos.
Sir, your bond is $5,000 on count one, $100 on count two.
Senhor, a sua fiança é de $5.000 na acusação 1 e de $100 na acusação 2.
You can have no contact with the victim. Do you understand what no contact means?
Você não pode ter nenhum contato com a vítima. Você entende o que não ter contato quer dizer?
Sim.
Yes.
You can't possess a weapon of any kind, a firearm or ammunition? Do you have belongings at that residence you need to gather?
Você não pode ter armas de nenhum tipo, especialmente armas de fogo. Você não pode ter nenhuma arma. E você tem algum pertence seu naquela residência?
Todos, documento, carteira, tudo ficou lá.
Yes, documents and wallet, everything stayed there.
All right, I'm going to order you must maintain a separate residence, and I will allow a one-time return with law enforcement to gather your belongings.
Ok, eu vou determinar que você precisa manter uma residência separada e eu vou agendar uma data para um oficial de polícia ir até o local com você para você coletar os seus pertences.
After that return, one time with law enforcement, you cannot be within 500 feet of the victim's residence or place of employment. Do you understand?
Depois deste retorno, em uma ocasião com um oficial de polícia, que acontecerá em uma ocasião apenas, você deve manter pelo menos 500 pés de distância da vítima. Você está entendendo isso?
Ok.
Yes.
All right, good luck, sir.
And Your Honor,
Ok, boa sorte, senhor.
Oh, that's right. Wait, also, sir, you have a hold from immigration. So at this time, even if you post bond, you will not be released until that hold is cleared.
Senhor, neste momento você tem uma suspensão da imigração, então mesmo que a fiança seja paga, você não será libertado ainda.
All right, good luck.
Ok, boa sorte.
Fazer uma pergunta?
Can I ask a question?
You can ask anything you want. Everything you say is being recorded and can be used against you later. Do you understand?
Você pode perguntar o que quiser, mas esteja ciente de que tudo está sendo gravado e o que você disser poderá ser usado contra você mais tarde.
Em relação aos meus filhos também, eu vou ter que ficar longe?
In regards to my kids, will I also have to stay away from them?
Can the state advise were the kids present for the incident?
O Estado pode dizer se as crianças estavam presentes com relação a este incidente?
Your Honor, the affidavit notes that the children were inside the residence. I believe the event happened inside the residence. However, I don't see any notes regarding if they observed the alleged battery.
The interpreter would like to clarify, they were inside or they were not inside?
They were inside the residence.
O Estado gostaria de dizer que, de acordo com a declaração, as crianças estavam dentro da residência no momento do incidente, mas não há nenhuma informação informando se eles presenciaram ou observaram o ocorrido ou não.
So I will order that you must comply with any plan set in place by DCF, and you can only have supervised contact with the children.
Então eu vou determinar que você precisa estar de acordo com qualquer determinação ou plano determinado pelo Departamento de Famílias e você poderá ter visitas supervisionadas com eles de acordo com o que for determinado.
Your Honor, I would just ask that you only order that he complies with any plan set in place by DCF. We don't know if the children were present, observed anything that happened in the arrest affidavit. So because of that, I would just ask that he complies with any plan set in place by DCF.
Meritíssimo, gostaria de solicitar que se você determine simplesmente que ele esteja de acordo com o que for determinado pelo Departamento de Família, porque de acordo com a declaração, não há evidência de que as crianças presenciaram o que ocorreu, então neste documento de prisão não foi mencionado nada disso.
Thank you, Counselor, but I'm not going to do that at this time. One of the allegations is that he took a knife and said, "I'll give you a reason to fear me."
Obrigado, advogado, mas neste momento eu não vou fazer isso, porque uma das alegações foi que no momento do incidente ele pegou uma faca e disse, eu vou te dar uma razão para ficar com medo de mim.
At this time, for the safety of the victim as well as the children, I'm ordering that he can only have supervised contact with the children.
Neste momento, para a segurança da vítima e das crianças, eu vou ordenar que ele apenas tenha contato supervisionado com as crianças.
Make sure you speak with your attorney about how to coordinate that, because you cannot coordinate visitation with the children through the victim. No contact with the victim.
Por favor, certifique-se de combinar isso com seu advogado para fazer arranjos para poder ver as crianças de forma supervisionada, porque você não pode coordenar isso com a vítima.
All right, good luck, sir.
Ok, boa sorte, senhor.
That's all we have for the Portuguese interpreter at this time. Thank you.
Thank you, Your Honor. Have a great day.
You as well.
Thank you.
All right. Can I stay on this line and connect with the interpreter? The Spanish? I don't know that I can. Do I have Attorney Witt? Is that who I have on the line?
Yes, ma'am.
I might have to disconnect with you in order to get the Spanish interpreter.
I'd like to say this is the first time a judge will have hung up on me, but that wouldn't be true.
Hold on one second. This is his motion. Hold on, everyone. Can we just do his motion right now, Ms. May? Are you prepared?
Yes, Your Honor.
All right. I don't want to lose him and then not be able to get him back for some reason. So case number 21 CF 11732, is that what you're here on, Mr.
It
Witt?
is, Your Honor. Yes, ma'am.
Your Honor, state asked that you grant that motion. State filed a notice of non-filing on 10-1.
Do we have his motion? Do you have it? Hold on one moment. All right. No. All right, I will grant that motion, Counselor.
Thank you, Your Honor.
I just signed the order. Is there anything else?
No, Judge, that concludes my business before your court this morning. May I be excused?
Absolutely. Thank you for appearing virtually. And also, well done on the tie with the wall.
Oh, yes. Thank you very much. It's nice meeting you. Take
I don't know if that was a plan, but good job. All right, have a great day.
Bye-bye.
All right, I'm going to disconnect with this and get the interpreter. I don't know if this is the right number. Maybe.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good morning, thank you. Please connect with the headset.
Sí.
There is contact, Your Honor.
Sir, please tell me your name.
Franco Chacón Hernández.
Franco Chacón Hernández.
This is 21 CF 13077. You're here charged with felony battery. At this time, I'll appoint an attorney to represent you. There is probable cause here. Your bond is $5,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Sí.
Yes.
You cannot possess or consume any alcoholic beverages. You cannot possess a weapon of any kind, firearm or ammunition. Is the residence where this occurred where you live?
Sí, yes.
Yes.
All right, I'm going to order that you must maintain a separate residence from all the victims and witnesses in this case. I'll allow a one-time return with law enforcement to gather your belongings if that's needed. Do you understand?
Yes.
Yes.
Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Ervin Rodrigo Robles Perez.
Kelvin Rodrigo Robles Perez.
This is 21 CF 13109. You're here charged with possession of cocaine and battery domestic violence. At this time, I'm appointing an attorney to represent you. There is probable cause here. Your bond is $1,000 on count 1, $1,000 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You cannot possess or consume any alcoholic beverages or any controlled substances without a valid prescription. You must maintain a separate residence. I will allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Sí.
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir. Please tell me your name.
Cosme Castañeda. Cosme Castañeda.
Cosme Castañeda.
21 MM 7023. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case.
Your Honor, when setting bond, we just ask that you take into account a few things. One, I'm unsure of his community ties to Orange County. Two, he does have a prior probation violation showing an inability to comply with court orders. And arguably in this case, there should be a bat DV against the wife, there should be a bat DV against the 20-year-old son, and there should be an assault on the 11-year-old son. I understand the officer only charged the bat DV. However, would just like to bring it to your attention.
I thought the 11-year-old was a daughter.
Hombre.
It's a male.
Los de 11 años es niña.
11 years old, a girl.
And Your Honor,
Yeah, she's the one that called the police.
Keelan, yes.
Your Honor, his community ties have been verified. He's been here for over a year.
Yeah,
They would just ask if you're inclined to put him on PTR, you do PTR with bond.
And he's zero failures to appear, Your Honor.
This is an incredibly aggravated case, however, Counselor, and the court is struggling with reasonable bond conditions with which your client will comply that balance his right to bond with the safety of the victims in this case, as well as the citizens of Orange County. Here's what I'm going to do. I'm going to place you on pretrial release and require that you post a monetary bond. Your monetary bond will be $4,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes.
You cannot speak to them. You cannot text them. You cannot send a message through friends or family. You cannot contact them on social media. No contact at all. You cannot possess a weapon, firearm, or ammunition.
Okay.
I'm ordering that you must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings. After that one-time return with law enforcement, you cannot be within 1,000 feet of the victim's residence, place of employment, or the children's school. Do you understand what that means?
Three.
Yes.
You cannot have any unsupervised contact with any minor child under the age of 18. You must comply with any plan set in place by DCF. I'm going to raise that monetary bond. It will be $10,000, as well as pretrial release.
Your Honor, I don't know if I'm looking at the right one, but I don't see any criminal history.
Oh, hold on, I can't hear you.
I don't see any criminal history.
I don't see it either, Counselor, but again, this is a really aggravated case. He tells law enforcement that he's not a U.S. citizen, he's a citizen of Mexico. So the court is also concerned with securing his presence for his future court dates.
Your Honor, I believe there's also a history of domestic violence that hasn't been reported to law enforcement, according to the victim's testimony to the law enforcement officer.
And he threatened to kill his whole family, Counselor, and appears to be able to make good on that threat, as evidenced by this incredibly violent incident. So I'm concerned this isn't enough, but all right, that's it. I don't do that yet. Please tell me your name.
Julio Cruz.
Julio Cruz.
21MM7026. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Sí.
Yes.
You cannot possess a weapon, firearm, or ammunition.
Okay.
Okay.
You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings. After that, you cannot be within 500 feet of the victim's residence or place of employment or the witness school. You cannot have any unsupervised contact with any minor child under the age of 18. Did I say no weapons?
Yes, Your Honor.
Okay.
Okay.
All right. That's it. Please tell me your name.
Jose Vasquez.
Jose Vasquez.
Looks like you have a warrant out of Seminole County. I don't know if this is the right case number. It says 158106MM. The warrant is for an arraignment on violation of probation for charges of driving with no motor vehicle registration and DUI. Just a moment, I gotta go into the other queue to find this. And VOP arraignment for driving without a license and DUI. It says the bond is $500. Seems odd to me. Because it says there's 2 counts, but there's only 1 bond listed. Does anybody have any ideas?
I don't have any information, Your Honor.
All right, well, that's all I know. $500, so. Good luck, sir.
Okay.
We'll notify them you're here so they can come and get you. That was weird. We don't have any other Spanish cases right now?
No, Your Honor.
All right, thank you for the interpreter. I believe that's all we have for you at this time.
Thank you, Your Honor.
Do we have Creole or sign? Somebody now? Oh, he's not coming?
He's
How do I let her know? Okay, hold on.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
All right, this is 21MM7030. Miss George, I'm sorry, I was reading. Your client is not coming because he's, did you say medical or mental health?
He's medical, Your Honor.
All right, I'm going to appoint your office, Miss George.
I'll waive the appearance.
All right, give me one moment. There is probable cause.
Your Honor, do you mind announcing the name? I believe there potentially is a victim here.
This is Jose De Leon.
No.
No? All right.
Your Honor, if you're inclined to put him on PTR, state would ask for bond with PTR, given that law enforcement had to go to the house approximately 3 times before this incident.
And there is also an injunction that just expired. Does the state know who the victim is of that injunction?
I believe it was a different victim, Your Honor.
All right, I'm going to place him on pretrial release and require that he post a monetary bond, but I'll reduce that amount to $250. No victim contact, no witness contact, no weapons, firearms, or ammunition, not returned to the scene for any reason. That's all. Please tell me your name.
Kenneth Lafayette Hill Jr.
21MM235. This was a reset from the weekend. Miss George, I think your office was appointed, but if not, I'm appointing you today. Sir, you're here charged with trespass. And I don't know if there was an offer.
Is this for Mr. Hill?
Yes.
Yes, Your Honor. The offer conveyed was an adjudication, credit time served, and no return to the 7-Eleven.
Your Honor, he wants to accept the state's offer of an adjudication of guilt, credit time served. I briefly went over the rights he would be given up. He understands those rights, and he would like to plea of no contest.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Hill, you had the opportunity to discuss with your attorney the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights? I can't hear you.
Yes.
All right. Do you have any questions for me about the rights you're giving up?
No, I have no questions.
All right. Did you have a chance to review that plea form in front of you? It further explains those same rights. You're giving up your right to remain silent, your right to testify on your own behalf, your right to a jury trial when one is required. If you enter a plea of guilty or no contest today, you give up all those rights. You'll be sentenced today.
Yes.
All right. You understand that?
Yes.
All right. You understand that if you're on probation anywhere, this plea could violate that probation.
Yes.
You understand if you're not a U.S. citizen, you could be deported?
Yes.
Sir, have you ever been diagnosed with any mental health illnesses?
No.
No, you have not?
No.
Okay. Are you under the influence of any drugs or alcohol or anything else that could affect your ability to understand what you're doing here today?
No.
All right, sir. Then at this time, how do you wish to plead to the charge of trespass other than a structure or conveyance?
No contest.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 3 days that you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay that. I'll also order that you're not allowed to return to the 7-Eleven. Can the state give the address?
Yes, Your Honor. It's a 7-Eleven located at 481 North Orlando Avenue.
You understand you can't go back there? Do you understand that?
Yes. Yes.
All right. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Khabib.
21MO1130. You're here charged with disorderly conduct. This was also a reset from the weekend.
Yes, Your Honor. Given that it's a city case, the state's been authorized on the city's behalf to offer a withhold credit time served. And no return to the Wawa.
And he has 4 days, Your Honor.
4, thank you.
Your Honor, we went over the rights he would be given up. He understands those rights, and he would like to accept the state's offer of a withhold of adjudication credit time served.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Counselor, I don't know if I'm inclined to accept that offer. I showed that he was sentenced in September for an assault on a law enforcement officer, and the allegations in this affidavit are, you can put your hand down, sir, are also threats of violence. Was the sentence in September credit time served?
It was, Your Honor.
All right, sir, did you say your last name was Khabib?
Yes, ma'am.
All right, Mr.
I never assaulted no officer, ma'am.
Oh, listen, you don't have to explain it. Everything you say here is being recorded and can be used against you later. But Mr. Khabib, I want to make sure that you're able to enter a plea today and that you fully understand what you're doing. Have you ever been diagnosed with any mental health illness?
Yeah, parietal lobe damage.
All right, when were you diagnosed?
Well, I had a assault when I was a kid, and a CT scan showed I was severely damaged right brain.
All right, so you've been living with that for most of your life?
Since '92.
Does it affect your ability to understand what you're doing and make decisions?
Well, maybe a little nervousness and paralysis, like smaller on the left side.
All right, but are you able to understand what we're doing here in the courtroom today?
Right. I just want to let you know I never assaulted an officer. I'm mentally handicapped. But I know what you're saying, like for my plea deal.
Well, because I saw this conviction, it shows on my paperwork that you have a conviction in September, so that was just last month, it was about 30 days ago.
Assaulted an officer, but I'm just saying, I do accept the offer.
All right, before you can accept it, I have to decide if I'm going to sentence you to that. So in order to make that decision, I just need to make sure that you understand the rights you're giving up if you enter a plea of guilty or no contest. Do you understand those rights?
No contest, yes, ma'am.
So you understand that we're not going to have a jury trial, you're giving up your right to remain silent, you're giving up your right to testify on your own behalf.
Yes, ma'am.
Do you have any questions for me about those rights?
As long as it means that I'm getting this charge out the way and I go home today, like in layman's terms.
Wait, get a little closer to the microphone and say that one more time.
As long as it means like the judge told me, the lawyer told me, I get to go home the way, like to get it over with. That's what I'm saying.
That's what the sentence is that the states asked the court to impose. Yes.
I go home today if I accept this.
Right, if I agree to sentence you that way.
Yes, I plead no contest.
Okay, but you don't have any questions for me about the rights that you're giving up?
I've had this offer before, no contest, and take it.
All right, so you've had a chance before to discuss with an attorney these rights, and you're confident you understand it?
Just told me like right now, yes, ma'am.
All right. All right, sir, you understand that if you're on probation anywhere, this plea could violate that?
I don't have probation anywhere, ma'am.
I believe you, but I have to ask
understand,
everyone.
yes, I understand.
Yeah, just in case.
Yes, ma'am.
And if you're not a U.S. citizen, you know you could be deported.
I've been a U.S. citizen since '02 by INS immigration status.
All right. At this time, sir, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 4 days that you've been in custody. Sir, I have to order that you pay court costs. I'm going to give you a year to pay them.
Your Honor, state would ask that you also impose a no return to that Wawa.
Sir, you can't return to that Wawa. State, give me the address.
It's at 4100 East Colonial.
You know where that Wawa is, sir? Mr. Khabib?
Yes, ma'am.
You understand? Okay, good luck, sir. You have 30 days to appeal in writing.
I go home today, Your Honor?
Yes, sir.
Going that way.
Please tell me your name.
Ahmed Israel.
21MM7034. You're here charged with battery, domestic violence, criminal mischief, and trespass on property after warning.
No.
I'm going to appoint an attorney to represent you. There is probable cause here.
Okay.
Just a moment, sir. All right, sir. Your bond is $500 on count 1, $100 on counts 2 and 3. With special conditions, you can have no contact with the victim in this case. Do you understand what no contact means?
Can't call my father or anything like that.
I'm sorry?
Can't call my father or anything like that.
You can't call your mother.
Okay.
You can't speak to her. You can't send her a text message. You can't go to her residence. You can't contact her through friends or family or social media. No contact at all. You understand?
Okay.
You can't possess a weapon of any kind, firearm or ammunition. You cannot return to her residence for any reason or be within 500 feet of her residence. Do you understand that?
Yes.
Your Honor, the out on bond is the same victim. State's asking that you revoke it.
I'm going to. At this time, sir, I'm revoking your bond in 21 MM 5970.
Thank you so much.
I'm sorry?
So thank you so much.
All right, good luck, sir.
Your Honor, did you set it at 0?
Yes. When did you say we would have Creole? We don't know. All right, who's next? Because I don't have those. Yeah. I don't have any of those. Starts with an L. All right, good morning, counselor. If you want to put your appearance on record and then call your case.
Yes, Your Honor, for the record, my name is David Yergy III. Case number
21 MM 7014.
Yes, ma'am. Thank you.
All right, please tell me your name.
Austin Tyler Lamatina.
All right, you're here charged with battery, dating, violence. Counselor, did you wish to be heard on probable cause?
Yes, Your Honor. I don't believe there was probable cause. If you look at the affidavit and with the evidence we have, the victim showed up at my client's house and it was attempting to break the door in when this all took place. The victim lives and has a separate residence. They haven't been speaking to each other. He's told her not to come back. They've broken up. I mean, that was self-defense to begin with, but I don't believe there was even. She just showed up, and I have evidence to show that she was trying to kick the door in.
All right, what says the state?
Your Honor, for the BAT DV, state just has to prove that it was an unwillful touching against her will. In this case, there is a Ring camera. It does, I think you do hear the victim knocking on the door or banging on the door. But when the defendant opens the door, the victim testifies to kicking her multiple times, causing her to fall. She tries to get up. He kicks her again. She then loses consciousness and does not remember anything else. When law enforcement arrives, she is still unconscious on the, I believe, a bench in the front of the house, laying on the porch of the home unconscious when law enforcement arrives. There is nothing within this affidavit showing that it was either mutual combat or that she touched the defendant first. He opened the door and attacked her. Even though she was at his residence, she was knocking or banging on the door. It doesn't say that she was trying to break in. It says she was banging on the door due to her thinking that there was another person within his household. State would contend that there is PC for a BAT DV, given the victim's testimony and the officer finding her unconscious like the defendant or like the victim testified to.
Your Honor, I was at the residence and I have the photos in the video. The door opens out. She was trying to break the door down. There were other witnesses there, but the police did not take the testimony of the witnesses.
Respectfully, that's not within the affidavit, Your Honor, and PC has to be found off the four corners of this affidavit.
Counselor, have you seen the affidavit?
No, I have not.
All right, I'll tell you the part that's hanging me up. I understand your argument, but on page 2 of the affidavit, it says your client called 911 for police assistance, and the officer had dispatch play back the audio recording from the 911 call. During this call, he tells dispatch that he pushed her and he needs police assistance. So I don't know if
She was Okay.
if there's potentially mutual combat or anything else. But I'll tell you why I thought there was probable cause, because she's unconscious on the ground. She makes the statement, he made her unconscious, and he says on the 911 call, I pushed her. So I'm not saying the state can,
What he pushed the door open, the door opens.
She opened the door, she opened the door. And then she was trying to get in, and I went like this to stop her from coming in the house. And that's where
Okay.
I didn't show her, she was inside basically.
Okay.
That's why I took the batteries out of the door.
Okay.
Your Honor, respectfully, that's not what the defendant said when law enforcement arrived. He said that his girlfriend of 3 months came over unexpectedly, banging on the door, yelling that she knew another female was inside the house. He told law enforcement that he called from inside the home requesting assistance, no visible signs of injury, and refused medical treatment. He admitted he'd been drinking all afternoon, and when he exited his home, she was laying on the ground and did not know how she ended up there.
right.
So,
Again, this would be the ex-girlfriend. He called me, and he was advised to call the police there because she was attempting to break in.
he never told law enforcement that she was attempting to break in, just that she was banging on the door, and the Ring camera corroborates that.
And we have the ring footage, but we also have the pictures of the door. I've had taken them, and you can see it attempting to kick the door in, or where there are footprints that look exactly like her.
Your Honor,
Do you have that with you?
Yes, I do.
Because that's not in the affidavit.
Your Honor, again, respectfully, PC is off the four corners of this affidavit. These arguments are for another hearing at a later time. They're just PC'd on whether Mr. Lamatina put his hands on the victim against her will, which the affidavit clearly shows he did. And his story changed once law enforcement arrived versus what he's telling the court here today.
And what's on the 911 call?
And what's on the 911 call.
So the very first full paragraph in the affidavit says, your client stated his girlfriend, not his ex-girlfriend, of 3 months came over to his house unexpectedly, started banging on his door and yelling that she knew he was with another female inside the home. He told me that he called police from inside the home and requested police assistance. He had no visible signs of injury. He admitted he'd been drinking all afternoon. He then says when he exited the home, he saw her lying on the ground, but did not know how she ended up there. But on the 911 call, he says, I pushed her. So,
Your Honor, if you look at the ring footage, she sent text messages to him before this that she was coming over, that she was going to quote, ruin his life, and then she's posting pictures on Instagram after it and taking selfies, and it's all on the ring footage there. So she planned this out, and
These are all arguments for a motion to dismiss, not for a PC determination, Your Honor.
right, I mean, it sounds like you may have some wonderful defenses and perhaps a motion to dismiss, but probable cause is a really low burden.
I understand that. But the fact that she drove to his residence, he's in his own, it is protect himself. But I understand where you're coming with the probable cause. But
Just because she came to his residence doesn't mean she gave him permission to touch her. That's the problem.
If she was trying to break in,
There's no allegations in this affidavit that she was trying to break in.
Right, I don't see anything here that says that. She started banging on his door. He calls 911. He's been drinking all day. He says to 911, I pushed her. So it doesn't say in here that he says to dispatch, she attacked me and I pushed her to get her off me. He just says, I pushed her and I need police assistance. So again, I think you have some great arguments. I just don't think it's probable cause. I think there's probable cause here in this affidavit for the arrest.
understood.
And your attorney will explain this to you better and in more detail, Mr. Lamatina, but I'm not saying the state has a great case or they can win this at a jury trial. I'm not saying, it sounds like you have great defenses and possibly a motion to dismiss, but at this stage, the only thing we're evaluating is whether there's probable cause in the affidavit, and then I set bond for you. So I just want you to understand, I'm not saying the state's gonna win this. I'm just saying there's cause to believe you probably touched her against her will. That's all this is. All right, Counselor, did you want to be heard on bond?
Yes, Your Honor. I would ask that the bond be waived, but if I understand,
Well, he qualifies for pretrial release.
we would request for pretrial release, excuse me.
You would?
Yes.
All right, does the state object to pretrial release?
No, Your Honor, state would ask for bond with pretrial release, given we don't have the victim's testimony here today, and given that she was found unconscious.
When was your client in the Army?
What was that?
When was your client in the Army?
2013 to 2017.
Where were you stationed?
Schofield Barracks, Oahu, Hawaii.
Well, that's not a bad 4 years. Thank you for your service.
Thank you for your support.
All right, I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
And make sure that you have conversations with your attorney about what to do if she comes back to your residence. Because this court does not have jurisdiction over her, so I cannot order her to stay away from you. But I can order you to have no contact with her. You understand?
Yes, Your Honor.
All right, you can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages. You'll be subject to random alcohol screens. Do you have any reason to return to her residence?
No, Your Honor.
No, Your Honor.
Okay, so I'm going to order that you can't return to her residence. But again, make sure that you talk to your attorney about how to protect yourself, because if I can't stop her from contacting you. You understand?
Yes, Your Honor.
All right, good luck. Anything else, Counselor?
What was the bond that said at?
I didn't. It's
Oh.
pretrial release.
Okay, thank you.
Yes, sir. Creole is ready on Cisco. Is this Creole? Okay, hold on.
Welcome to an Econo meeting. You are entering the meeting now.
Good morning, this is Judge Gibson. Can you hear me?
Hi, yes, good morning.
Has the interpreter been sworn today?
I have not.
All right, please raise your right hand to be sworn.
Do you swear to interpret from Creole to English, English to Creole, the testimonies you will receive today?
I do. Isabel DeRocher, court interpreter, Creole.
Thank you very much. Sir, please tell me your name.
Monsieur qui Jean Brélé?
Nixon Bullshit.
Jean Nixon qui ça?
Nixon Bullshit.
Nixon Bullshit.
Oui.
Sir, you're here in 21 CF 13080, charged with domestic battery by strangulation, false imprisonment, domestic battery, and battery.
I'm sorry, Judge. Battery?
By strangulation.
Okay.
False imprisonment, and battery domestic violence.
Okay. Monsieur Ouissia, dans le cas 21 CF 13080, ou accusé que ou t'es attaqué un monde, ou t'es tranglé li, ou t'es emprisonné li, et ou t'es attaqué li.
I'm going to appoint an attorney to represent you.
Ma bon avocat pour représenter ou?
Ms. May?
Yes, Your Honor. I believe PC was already found on count 1, the bat by strangulation, and count 3, the bat DV.
Nous pensons que nous te gain temps joindre et assez évidence pour accusation de que ou t'es tranglé moun là et que ou t'es attaqué li.
We are here because it was reset as to count 2, the false imprisonment.
Nous là parce que nous te remettez en l'autre date pour et emprisonnement.
The state was not able to obtain a new affidavit. However, would like to make the argument that PC is already in the affidavit.
Did we lose the interpreter?
It appears so.
Oh, no. Let's see if she just reconnects. Just a moment.
You are the only participant.
It's like a super sad thing. Like, no one wants to be here with you. I don't know if it helps if I reconnect or if it helps if I stay on the line. Because wouldn't it be the same, she just has to reconnect?
I think she is, Your Honor.
Hi, I'm not sure what happened.
We're not either, but I'm glad you're back.
Okay.
I'm going to ask the prosecutor to repeat what she just said so we can start
Yes.
there.
Yes, please.
I believe that we are here for a PC determination as to count 2, the false imprisonment and DV.
Dis-moi, pensez que nous là pour une détermination de cause probable pour deuxième chef accusation qui c'est emprisonnement.
I was not able to obtain a new affidavit from the law enforcement officer. However, state contends that there is PC already within the original affidavit.
Dis-moi, pas t'es capable de une attestation dans main et la police qui t'a arrêté, monsieur, mais nous décidé que gain assez pour joindre notre premier attestation.
For a false imprisonment, the state has approved 2 elements. One, that the defendants forcibly or secretly by threat combined, abducted, imprisoned, or restrained the defendant.
Que monsieur a été soit par force ou bien par menace que l'était emprisonné, qu'imbé ou bien empêché moun la quitter.
And that the defendant had no lawful authority to do so.
Et que accusé pas te gain aucune autorité fait baga ça.
Within the affidavit, it reads that Mr. Nixon grabbed her by the neck with both hands around her throat.
Dina et accusation elle dit que ou te prend avec 2 mains autour de coulis.
The victim tried to get him off of her.
La victime l'a essayé pousser ou.
And then once she tried to leave the apartment, he grabbed her by the hair.
Après que tu essayé quitter l'appartement ou te prendre pas chevelu.
While standing at the front door of the apartment and told her she could not go anywhere.
Pendant que tu es dans porte devant l'appartement et tu dit moun la que li pas te capable aller aucun côté.
She tried to grab anything in sight to throw at him to escape.
Li te essayé joindre quelque bagay dans là que li te capable et prend pour jeter sur ou.
And at that point, she was able to call law enforcement.
Et le ça li te capable de la police.
State contends that the initial grabbing her by her hair while standing at the front door and telling her she could not go anywhere was a false imprisonment.
L'État dit que Kembe dame la pas chevelu, était dans porte devant et dit que li pas était capable d'aller aucun côté, baga ça fait que c'est un emprisonnement.
The victim had to resort to her own devices to defend and get out of that confinement.
Victime l'a été obligée faire tout ça, elle était capable pour tête li pour sortir de emprisonnement ça.
There's nothing within the statute nor in the jury instruction of how long that imprisonment has to be for, however slight or trivial.
Pas gain aucun bagay dans la loi qui dit combien de temps bagay la ta doit durer ou bien pour combien de temps l'état doit y.
The state contends that he forcibly confined her against her will and he had no lawful authority to do so when she was trying to leave the apartment.
Simplement, la loi dit que ou t'es empêché d'am là, ou t'es kembel contre volonté li, et que ou t'es empêché d'aller, le li te vle aller.
That's all I have, Your Honor.
Et c'est ça seulement moi qui un juge. Can I have something that I have to ask?
Sir, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Dis monsieur ou capable de dire tout ça ou vle, mais tout ça ou a dit enregistré et capable d'utiliser par après. Est-ce que vous comprenez ça? Pardon?
Ça signifie.
What does that mean?
It means that you don't have to say anything right now, but if you choose to speak, the state, which is the agency prosecuting you for this crime, can use anything you say against you later to prosecute you.
OK, ça veut dire que ou met dit ça ou dit ça ou mais l'État qui c'est l'agence qui a prosécuté ou capable prendre ça ou dit et utiliser le compte ou même par après.
Let me ask your attorney if she has anything she'd like to say to you before you speak to the court.
Quittez-moi demander avocat si il y a quelque bagage que l'État veut dire ou avant ou parler avec juge là.
Madam Interpreter, could you please advise the client, I would suggest he not talk about the facts of the case.
The avocat dit que l'État mandé ou pas parler de bagay qui en dans cas. Bagay qui fait que cas a là.
Do you understand your attorney's advice, sir?
Est-ce qu'on comprend ça, avocat so dire?
Non, pas dans les Algériens, non.
Pardon?
Batandil.
I did not hear.
One more time, Ms. George.
I would advise, could you please advise the client not to talk about the facts of the case today?
Il dit, avocat t'a conseillé ou pas parler de cas aujourd'hui. Pas parler de rien de cas aujourd'hui.
Do you understand your, oh, go ahead.
I have nothing else to say about that.
All right, do you understand your attorney's advice, sir?
Est-ce qu'on comprend ça, avocat Abdiou?
Alors?
Est-ce qu'on comprend ça, avocat Abdiou?
Ça le pas le dire?
Est-ce que vous comprenez ça, avocat Abdiou?
Ça le dit tout à l'heure?
What she just said, like now?
Yes.
Oui.
Oui.
All right. Then do you still wish to speak to the court, or would you rather wait and speak with your attorney?
Est-ce que vous toujours voulez parler avec tribunal là, ou bien est-ce que tu as plutôt resté ton et parler avec avocat ou plutôt?
Oui, David parler à avocat.
Rather speak to my attorney.
All right, sir. I think that's a wise choice.
Ok, monsieur, moi, je pense que c'est un bon choix.
Let me ask Ms. George, did you have any response to the state's argument?
Est-ce que Madame Georges a quelques réponses de argument l'État?
Your Honor, my only argument is that the weekend judge found no PC on count 2. The state was to provide a supplement, which they did not provide, so I would just ask that you ROR him as to count 2.
Moi, je voulais simplement dire que nous pas joindre aucune cause probable sous deuxième chef accusation, qui donc m'a un supplément que nous pas recevoir. Donc, m'a demandé juge là simplement pour les quitter le sorti sous bon parole sous deuxième chef accusation.
Thank you both for the arguments. I read the statute myself, Florida Statute 787.02.
Et moi, j'ai regardé la loi 787.02.
There are only 2 elements the state has to prove for a charge of false imprisonment.
Seul bagay l'État besoin de prouver pour une accusation de mauvais emprisonnement.
This court finds there is probable cause that your client forcibly and by threat, by grabbing her hair and telling her she could not leave, there's probable cause to believe that he committed the crime of false imprisonment.
Il dit, moi, joindre que l'État, ça d'après l'État te dit, c'est 2 bagages que nous besoin prouver pour faux emprisonnement. L'État prend le pas chevelu, l'État dit que l'État pas été capable d'aller, qui donc c'est cause probable pour faux emprisonnement.
Further, her statements in the affidavit that she wanted to leave, she tried to leave, and he wouldn't let her is the second element, that it was against her will.
Et deuxième élément qui était contre volonté li, c'est que l'était écrit dans l'attestation li que l'était voulait aller, que l'était demandé pour aller et que l'était pas été capable d'aller.
Does the state object to pretrial release in this case?
Est-ce que l'État a un problème pour relâcher avant procès dans cas ça?
Ça le dit.
Your Honor, state would just ask for bond with PTR, given his prior arrest history.
You are the only participant.
It's like every Monday.
I am back. I keep getting kicked out for some reason.
I'm so sorry. I don't know what's going on. Thank you for coming back. All right,
You're
sir.
welcome.
I'm going to place you on pretrial release.
Your Honor,
Monsieur m'a mette ou nan relâche avant procès.
he also had a 2020 misdemeanor non-arrest, bat DV, same victim.
Ou te gen yon ti de mineur de on attaque tout sous même victime.
A 2020 false imprisonment DV, bat DV, same victim from March 2020.
Depuis en mars 2020, ou te gen un lot cas de violence domestique, attaque pour violence domestique.
He also had a ag bat with a weapon DV, criminal mischief, and bat DV, also from 2020. I believe it was the end of 2019, and we declined to prosecute in 2020. However, that one was a different victim.
Te gen un lot cas que te gen en fin 2019 qui te rempli en 2020 de attaque grave avec 11 armes et attaque sous violence domestique avec un lot victime.
He also had an additional 2019 misdemeanor non-arrest and a 2020 additional misdemeanor non-arrest bat DV cases, both the same victim as well.
Et ou te gen un lot cas d'élimineur de 2019 des attaques et violences domestiques sous même victime là encore.
All of the non-arrests were declined to prosecute due to the victim being unwilling to prosecute. However, it just shows the length of time between this victim and this defendant and the nature between them.
Nous pas te capable prosécuter accusation sa yo parce que victime la pas te vle vini témoigner mais baga ça a montré depuis combien de temps il y a un problème entre deux moun sa yo et qui qualité relation yon gen ensemble avec l'autre.
All right, sir, I will also require that you post a monetary bond.
M'a demandé monsieur pour mettre aux caution monétaire.
On count 1, it will be $1,000.
C'est $1,000 sous premier chef accusation.
Count 2 will be $150 and count 3 will be $100.
Deuxième, c'est $150 et troisième, $100.
You can have no contact with the victim. Do you understand what no contact means?
Ou pas capable de gagner aucun contact avec victime là. Est-ce que vous comprenez qui ça? Zéro contact veut dire?
Oui.
Yes.
Ça pose une question?
Can I ask something?
Yes.
Ça pour mal. Vous me payez comme ça? Alors? Ça pour me payer lui?
That money, I have to pay that?
Yes.
Today?
Oui. Today?
It's up to you when you pay it.
Ça dépend de où qu'il a payé lui.
But that's to be released.
Mais c'est pour capable sortir.
Oui.
Yes.
You can't possess a weapon of any kind, firearm or ammunition.
Ou pas capable de gagner aucune arme du tout, aucune arme à feu, aucune munition.
Pose une question, s'il vous plaît.
Can I ask a question again, please?
Yes.
Depuis le fait, pas de arme dans vie.
I never had any weapon.
Okay, that's fine. Then it will be easy to comply with that order.
OK, donc pas de problème, libre facile pour capable obéir l'autre ça.
You cannot possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens.
Ou pas capable prendre aucune drogue ou bien aucun alcool et il a checké souvent et à tout hasard pour voir si tu prends alcool.
You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Ou capable, ou besoin rester dans l'autre caille que victime là, ou capable retourner la caille ou en graine fois ensemble avec la police pour aller prendre affaire, mais ou pas capable coordonner bagage ça ensemble avec victime là. Est-ce que vous comprenez?
OK.
OK.
After that return, you cannot be within 500 feet of the victim's residence or place of employment.
Après, bagage ça ou pas capable à moins que 500 pieds de victime là côté li rete et côté li travail. Pardon?
I
don't know where she works.
Okay. Good luck, sir.
Thank you.
Bonne chance, monsieur.
Passez bonne journée.
All right, I
Have a
believe
good
that's all
day.
we have for you, ma'am.
Thank you. Sorry about the technical difficulties.
No, thank you for your patience.
All right. Bye-bye.
Good morning, Judge Gibson.
Good morning, Counselor. Go ahead, put your appearance on record and
Brian Bird, BYRD, on behalf of Valeria Toshev. Your Honor, we have a couple of matters to address. The alleged victim is present in the gallery. I believe he'll want to make a statement. I know he wants contact. He does not want to prosecute, but I am here to challenge probable cause based on the four corners of the initial document, and also as well, Your Honor, formal pleadings to file.
all right, this is 21 MM 7020. Ma'am, you're charged with battery domestic violence.
Yes, Your Honor.
Do you want to argue first, or do you want to take testimony first?
I'd like to just argue, Your Honor.
All right, go ahead, Counselor.
Regarding the probable cause argument in this case, if you actually look at the four corners of the document, the original probable cause affidavit, you have two scenarios that are almost exactly the same when relayed by both the defendant and the alleged victim. The only difference is, and law enforcement did not include, to my recollection, I just read it in there, whether or not they addressed this specifically with the defendant, the victim. Ms. Toshev alleges that she was thrown to the ground violently in this circumstance. And there, the only injury that the alleged victim suffered was he had a scratch on his face. We would say that that obviously is a defensive maneuver, very common defensively. The law enforcement officer made a credibility determination solely based, and this is a mere hunch, as the court knows, mere hunches is not even a basis for reasonable suspicion. And while the court previously said probable cause is a low standard, it's lower, obviously, than reasonable suspicion. Solely based, the determination of credibility finding by the officer was solely based by her skin color. I would present to the court that this is a 5 foot, maybe 5'1", 100-pound woman. She is of not super pale complexion. I think she's darker than me. That is the entire basis to find that she did not act in self-defense. Your Honor, based on the four corners of the document, there is no probable cause. There is no way to determine an initial aggressor. There is nothing here. So we would strongly argue that there is no PC to be found based on the four corners of the document. Any other different officer at a different day could have just as soon taken the alleged victim to jail under these circumstances.
All right, thank you, Counselor. Anything else at this time?
Just based on the probable cause finding, obviously, we would follow up.
All right. Ms. May, any response from the state?
Yes, Your Honor. First, there is allegations within the affidavit from the victim or from the defendant herself. She told law enforcement that she took the iPad from her son, went to the victim and tapped him because she did not want him to have it. So the victim allegedly, or the defendant allegedly touches the victim before the victim ever touches the victim. I'm sorry, that was very convoluted. But the victim herself told law enforcement that she tapped the victim, or the defendant. Whew, okay. And then at that point, she advised that the victim grabbed her by the arms and she then kicked him and grabbed his face. However, she tells law enforcement herself that she touched the victim first. Law enforcement does not see any visible injuries on her body, which would be sufficient with her being pushed to the floor and kicked and hurting her head and neck. Law enforcement does not observe any of that. Law enforcement does make contact also with the victim. He has a very obvious large red mark on his left cheek. He tells law enforcement that she was upset about her giving the iPad to the son, and she hit him several times in the arm. He told her to stop, but she continued to hit him to get away.
I will just make one argument, Your Honor. Obviously, whenever you involve self-defense, it is a reasonable determination. Somebody tapping you with an iPad does not give basis to throw them on the ground. And here, we have a credibility determination made by the officer not finding marks in this circumstance. The court knows marks can show up later. They can show up not at all. And this is a mere hunch, Your Honor. It's not even reasonable suspicion.
Again, the victim allegedly tells law enforcement that she touched the victim first. Then victim gives his account that it wasn't a mere tapping, it was much more than that. So from the victim's own testimony, she touched him first in whatever manner, a tap or with what the victim says, more than a tap, hitting him several times, not stopping. She allegedly hit him first. And the victim testifies to law enforcement that that was more than a tap. However, the victim or the defendant said that she at least touched him first.
So the state's contention is that when the defendant says that she tapped him with the iPad, that's the battery because it's an intentional touching against his will?
No, Your Honor. The state alleges that the victim's testimony is that she hit him several times in the arm. He told her to stop. She was upset. She was upset and he was trying to make her to stop.
So that's the victim's statement
That's
about
the
her
victim's
hitting him.
testimony, Your Honor.
And the defendant's statement is she tapped him. So even if we,
I'm making the assumption or making the argument that she is the initial aggressor. From her own testimony, she touched him in whatever manner first. But from the victim's own testimony, which was under oath and to an officer, that this is sufficient for a probable cause determination that he touched her against her will as she touched him first.
Still a legal standard, Your Honor.
all right. Sir, did you want to testify this morning?
If you have a question, I can answer. But,
I can't hear you. You have to get really close to the mic. Sorry. For tall people, you got to bend down.
no, I don't want to testify, but if you have any questions, I can answer.
All right. Raise your right hand, please. I think the prosecutor or the defense attorney might have questions.
Okay. But okay.
Raise your right hand to be sworn, then we'll ask you questions.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I'm sorry?
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Sobir Toshev, last name Toshev.
All right. Does either of the attorneys want to ask any questions?
Thank you, Your Honor. I'll just ask a couple simple questions after
Okay.
speaking to my client before keeping it limited. Do you wish to have contact with your wife?
Yes.
All right. You want her to come back home with you?
I want to come back home, take care of kids, and I believe what happened was the misunderstanding. We both.
Okay, well that's fine. I want to inquire. Do you want the state to press charges, or do you not want the state to go forward?
I don't want any charges.
Okay, and we'll follow up with a formal declination if he would like to do that. Your Honor, I will make this easier. I would just ask that the court ROR her on this charge. I certainly think, based on the argument that we made, I understand the state's contention, and whether the court thinks it's a close matter, I certainly think this is worthy of an ROR, not burdening her of pretrial release. She has no criminal record, none, and she's got 2 children here, and certainly she was not in any way, this is a de minimis case at best.
Before we go any further, hold on. Can I have the attorneys approach,
Yes.
please? Give us one moment. All right, sorry about that. I had to ask the attorneys some questions.
Yes, Your Honor.
All right.
In regards to counsel's request for
Wait,
ROR.
wait. Before you do that, do you have any questions for the witness?
No, Your Honor.
Okay. Go ahead with your argument.
Under 907.041, there is no ROR for dangerous crimes. Arguably, a battery falls under the dangerous crimes. So state would ask that you put her on pretrial release.
Wait, 907 what?
.041.
Your Honor, I've received ROR on several DV cases before. I understand the counsel's argument, but
Dangerous crime means the enumerated offenses. I see aggravated assault, aggravated battery, child abuse, kidnapping, homicide, manslaughter, sexual battery, act of domestic violence as defined in 741.28. Let's go there.
It's a good argument, counsel. It's a good argument. I've never had somebody make that argument before.
I haven't either, and although I don't think I've ever ROR'd someone on a domestic case, so we've not had this argument. And of course, 741.28 is not in my book.
Would you like me to print it for you, Your Honor?
Yes, do you have it handy? I can Google it, or
I have
Westlaw
right here.
it.
It defines what domestic violence is.
According to that, yes, if a probable cause determination was found, yes, it would qualify under that.
All right. So then the question would be, your client does qualify for pretrial release?
Would you like it, Your Honor?
Yes, please. Or I could set a very low monetary bond.
Yes, Your Honor, we would
What would
ask,
she prefer?
we would ask a $100 bond. I'd try to keep her away from pretrial release.
Yeah, it doesn't, it's here. All right, I appreciate the arguments from both sides. I do think, however thin, there is probable cause here. But I will set the bond at $100. And based on the testimony here this morning, sir, I'm going to allow her to have contact with you. That's what you said you wanted, right?
Yes.
All right, so ma'am, you can have peaceful contact with your husband. Do you understand what peaceful contact means? No hostile contact. So if you have questions, make sure you talk to your attorney about that, because I have to advise you, if there's an argument and people are shoving or something to that effect, and you get arrested again, you can be held at no bond for violating a condition of your release. So you want to make sure that it's peaceful contact. I'm going to allow her to return to the home. You can't possess a weapon, firearm, or ammunition. And are there any other conditions the state would request?
No, Your Honor.
I'm not imposing any others.
Thank you.
All right, thank you.
Thank you.
That's all I have. May I be excused?
Yes.
Thank you, Judge.
Good luck to both of you. Thank you for coming, sir. Okay.
Thank you.
Counselor, if you want to call your case.
Yes, Judge. Lazaro Blanco on behalf of Justin Figueroa. And I had his case number just now, Judge. And
It's 21 CF 13018.
Okay. Yes, Judge.
All right, and we're back.
Yes, Judge. I believe this was a recall from Friday. I believe that Judge Bain had found probable cause on several of the charges. I think we're hung up on one of the charges. To the best of my recollection, it's count 15. There was no, I wasn't here on Friday because they hadn't retained me yet. But I believe that the issue there was, well, first, it's a constructive possession. We're just looking at the four corners of the affidavit, as we've been doing all morning. There's no weight with regard to the cocaine that was found, and also it's a constructive possession case that was found.
I guess that's the supplement.
Okay. And then there was I just was handed something, Judge, here. It's 2 lines. Let me just read it.
Waiting for his argument. I don't want to interrupt.
Oh, I'm sorry.
Thank you, thank you.
Yes, Your Honor. Judge Bain did find PC for all counts except the count 15, which is the cocaine, due to there not being an amount listed by the law enforcement officer. State was able to obtain an additional affidavit from that law enforcement officer stating that the weight of it was 42 grams, well over 28. So state contends that there's PC for count 15, as that's the only thing Judge Bain did not find PC for.
All right, I'll give the defense a moment to review that affidavit.
Okay. Well, Judge, I just reviewed that. I don't exactly know it's not clear how they weighed it, what type of weight, what kind of scale they used or anything like that. So I would argue that, the accuracy of that might be in question. It still has to go to FDLE to get an accurate weight. To have something that's exactly 42 grams is pretty, it's not common, it's exactly 42. That's questionable in my mind. And also with regard to ownership, when it's a jointly occupied vehicle, this bag was found behind the passenger seat. My client was the alleged driver, and there's no independent evidence of ownership with regard to what's in the bag. And he was just because he's a sole registered owner of the vehicle doesn't change the fact that that this was readily accessible by, I think the PC on the police report said this bag was readily accessible by both people, by both occupants. And when that's the case, I'm trying to see, I'm trying to look this up real quick. See, yeah, so the bag was within arm's reach of A1 and P1. So when you have something which is passenger and driver, so when you have, as far as case law wise, my recollection of the case law is that there has to be some sort of independent evidence in addition to what was found when you have a situation like this. So I believe that the independent evidence to charge Mr. Figueroa with possession of a trafficking amount of cocaine is in question. Well, according to the case law, I don't think it is, that they can't assign him actual possession. And the weight is also questionable. In my mind, it hasn't been weighed by FDLE. So I would ask that the court just set the case, set a bond for possession of cocaine, and not set a bond in an amount for trafficking of cocaine.
All right, thank you, Counselor. State?
Yes, Your Honor. In regards to his first argument that it must be weighed by FDLE, that is not the standard. We have PC all the time where law enforcement weight is sufficient for a PC determination. And at a later date, when state files an information, that's when FDLE's weight is taken into account. However, state would contend even if the scale was possibly miscalibrated, the statute is over 28 grams. He's allegedly had 42 grams, which is well over. It's not within a 0.1 or a 0.2 or something that might potentially be off. It's almost double. In regards to counsel's argument regarding possession, Judge Bain already found PC for other items that were also within that Adidas bag, finding joint constructive possession. The bag was behind the front passenger seat, so within arm's reach of the driver if he reached back. And I'm not aware of any case law regarding that there must be independent articles in it to prove ID, and counsel hasn't given us that case law. Under joint constructive possession and it being the defendant's vehicle that is solely registered to him, and given that Judge Bain has already found PC for other items within that bag, under joint constructive possession, state would contend that it was enough. The only PC the reason Judge Bain did not find PC was solely due to the weight of the cocaine, since the law enforcement officer did not place that in the original affidavit, and we now have that.
All right, thank you. Any response from the defense?
Judge, with regard to the constructive possession, I don't believe that if there's two people, well, I'd have to look up the exact case. I didn't bring a copy of it, of the exact case with me, but with regard to constructive possession, if it's a jointly occupied vehicle, there has to be some sort of independent evidence to assign possession to one or the other. That's the way I believe the case law is read, but if I'm mistaken, then I do apologize. But I just had this issue come up in another case. That's the only reason why it's kind of fresh in my mind. But no other argument other than that, Judge.
In brief response, Your Honor, under constructive possession, he just has to have the ability to exercise dominion and control over that bag. State contends that he can, as it was within his reach. It was behind the front passenger seat, which would be directly diagonal to him, which would be a comfortable reach. So state contends that there's enough for probable cause to that count.
All right, thank you both. Give me one moment.
Oh, I'm sorry, Judge, I forgot one thing.
Go ahead.
As far as as far as ties to the community, as far as setting a bond, I can proffer to the court that Mr. Figueroa is employed in Orange County. He has ties to the community. He's been living in Orlando for about 5 years, Mr. Figueroa, about 5 years, and he works at a painting company.
At a what?
A painter. He is a painter at Tingles. Is it Tingles Painting. And I know this is not a full-blown bond hearing, but I just kind of wanted to give a little bit of background when the court's deciding whether to set that or not. I mean, what amount to set, I'm sorry. Tingles Painting, he has ties here. He has his girlfriend lives here. He has children here as well. Children, his girlfriend lives here. He's been in Florida for about 15 years. So just to give a little background there, that's what I would have, that's the testimony that I would have given had I did that, but I just wanted to proffer that to the court.
All right, thank you, Counselor. Anything else from the state?
Your Honor, just in response to that, he does have 2 prior failures to appear. He does have a rather short criminal history, so there being 2 prior failures to appear are quite concerning due to a rather short history, including a prior VOP.
All right, thank you. Does anyone know why Judge Bain released him on his own recognizance?
As to 18
Counts.
through 31,
Yes,
just due to, it was multiple bullets.
I see.
That's all of, from 17 to 31 was all possession of ammunition. It was just multiple rounds.
I see.
Was that inside the magazine? Okay.
All right, I just wanted to make sure it was for that reason, because I see he treated others as subsidiary bonds, and I wanted to make sure I understood what the court said on Friday.
Yes, Your Honor, that was my understanding when he did it.
Because here's what I'm going to do. I appreciate the arguments from both sides. I do think there's probable cause for this charge, though you might have some great arguments for some motions later. I think it's not charged as a trafficking with a firearm. It's
Yes, Your
just
Honor.
trafficking.
It could have been, it was not.
So here's what I'm going to do. I'm going to set the bond at $50,000 on count 15. And
I believe the only condition Judge Bain set Friday was no drugs or alcohol without a valid prescription.
no contact with co-defendants or any known drug dealers. And I'm going to change count 1 to a $150 bond to treat that as a subsidiary. All right. Good luck, sir. Keep in touch with your attorney.
And Judge, do you know what division this will be in, or?
Wait, what?
Do you know what division this will be in? Was it Judge Strobridge?
I think it's Judge Strobridge.
Strobridge.
Yes.
Do you have the other bond amounts? Sorry? Do you have the other bond amounts?
Yeah, I
need
pulled it
those?
up on the computer. Yes. All right, thank you so much.
Okay.
All right, thank you, Judge.
Thank you, Counselor. Have a nice day.
Have a great day.
Please tell me your name.
Luis Delgado, Your Honor.
21 CF 13079. You're here charged with false imprisonment and battery by strangulation. Ms. May?
Yes, Your Honor. Judge, I believe this was over the weekend. The weekend judge found PC for count 2, did not find PC for count 1. May I approach?
Yes, sorry. I was reading and listening. Yeah, thank you.
I was able to obtain additional affidavits, but absent those affidavits, state still contends that the original affidavit is enough. State would point to 1, 2, 3, 4, the 5th paragraph down. He put his arm around her neck in a chokehold to get her out of the house and force her out the door. She was able to breathe, but he had his arm around her neck and she stated no, but kept screaming, get off, get off. He threw her up against the wall.
Is that it?
Yes, Your Honor, that he had his arm around her neck and was forcing her out the door against her will. She was screaming, get off, and he was still, again, then threw her against the wall and struck her left shoulder and head. She did not give him permission to touch her. The 2 additional affidavits provided to the court and both defense were from Officer Resolute and Officer Junco. In Officer Junco's report, he notes that he pinned her against the wall, then he pinned her against the ground. He jumped on her back and pinned her to the ground for approximately 2 minutes. When she attempted to get up, she was unable to because he was restraining her body and pinning her to the ground. As he was on top of her, he then began to strangle her, making it difficult for her to breathe, all while she was on the phone with law enforcement and, I believe, a friend.
All right, so tell me what the 2 elements are. Where are the 2 elements for the false imprisonment?
That he confined her against her will, Your Honor. He had her pinned to the floor. He had her pinned to the wall. That's in Officer Junco's report, also in the original affidavit. That he had her in a chokehold. She was saying, get off of me, and was trying to force her to do something that was against her will, and he had no right to do so.
All right, Ms. George, any response from the defense?
Not based on the supplement, Your Honor. The supplement, I think now there's PC. It looks like it stated he pinned her to the ground for approximately 2 minutes.
Right.
So I would just say based on the supplemental, that there's enough for PC.
I agree, there is probable cause there. All right, so at this time, your bond is $5,000 on count 1. $150 on count 2. You can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, Your Honor.
Yeah.
Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Your Honor, based on my look at his face sheet, I don't see any other criminal history. So based on that, I would ask for pretrial release.
What says the state?
Your Honor, state would object. There was an allegation of a firearm, and the victim, when she was contacted by pretrial release, was too afraid to even attend court. So state would object to pretrial release. I believe due to pretrial making victim contact and her saying she's too afraid to even come to court, she would object to pretrial release. If you're otherwise inclined to put them on pretrial release, state would ask for bond that you currently set with pretrial release.
What I'll do is I'll place you on pretrial release, sir, but I'm still going to require you post a monetary bond. I'll reduce it to $2,000 on count one, 100 on count two. Was there any allegation of substance or alcohol involved in this incident?
Not that I saw.
Don't
Your
recall
Honor.
it.
I didn't write any.
All right, good luck, sir.
Thank you.
We may have to take a recess soon. It's been a marathon to get 10 cases done.
Yes, I'm I feel you.
Please tell me your name.
Aisha Edie.
21 CF 13081. You're here charged with battery, domestic violence, and aggravated assault with a weapon, domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Ma'am, did you wish to testify?
No, ma'am.
All right, thank you. Does the state object to pretrial release?
Your Honor, state would ask for bond with pretrial release. I understand the victim does not want to call or doesn't want to testify. However, the allegations are rather concerning, including an additional criminal mischief. So state would ask for bond with pretrial release.
Anything from the defense, Ms. George?
Your Honor, she has no criminal history. It's not even showing any type of criminal arrest. She's employed full-time. I would just ask for pretrial release in this case.
I'm going to place you on pretrial release at this time and require that you post a monetary bond. However, I'll reduce that amount significantly. Count one will be $100, count two will be $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. You can't have any contact with any witness in this case either. Did I say no weapons? Yes. All right.
Your Honor, I believe there was an allegation of alcohol use.
You cannot possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens while on pretrial release. Do you understand that?
Yes, ma'am.
All right, good luck. Thank you, ma'am. Good luck.
S2, Winston is medical.
21 MM 7033, 21 CF 13103. Ms. George, I'm appointing your office in both of those cases.
I'll waive the appearance, Your Honor.
All right, there is probable cause. Is there a victim here in these cases? I just want to make sure.
I don't believe so.
All right. God bless you.
Excuse me.
All right, bond is $4,000 in the CF case, $5,000 in the MM case, no victim contact, no weapons, firearms, or ammunition, cannot be within 1,000 feet of the victim's residence or place of employment, and that's all. I'm sorry? Yes. Please tell me your name.
Valerie A. Griffin.
21 CF 13108. You're here charged with battery, domestic violence, robbery with a firearm, aggravated assault, domestic violence, and tampering with a witness. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor. For the robbery with the firearm, I would argue no PC. Based on the four corners of the arrest affidavit, it does not appear that the taking of the chain was by force. The alleged victim states he slaps the firearm and they begin to fight. And that's when the chain is ripped off in the midst of the fight. And then somewhere further down, it states that she was taking things out of his pockets and throwing them in the road. I would just argue that there is no robbery with the firearm. She didn't use the firearm to forcibly take the chain nor the wallet from the alleged victim. Therefore, I would argue no PC.
All right, what says the state?
Your Honor, for a robbery, state must prove, 1, the defendant took property from the victim. 2, it was by force. 3, the property was of some value. and 4, they had the intent to permanently or temporarily deprive them thereof. In this case, she shows up with a pink firearm. She shows up, then she goes back to her vehicle and says, I have something for you, and retrieves a pink firearm, pointing it at his chest, stating, I'm going to kill you. He was able to slap the firearm to her side, so it was no longer pointed directly at him. However, she did still have the firearm on her actual person. She broke the chain off his neck and threw it into the roadway, temporarily depriving him of that chain. She then went into his pants pockets, removed his wallet, and also threw it, also temporarily depriving him of his wallet. She also snatched his cell phone and threw it across, breaking the screen and the protective barrier, depriving him of his cell phone. And then also when law enforcement showed up and had her in custody, she was in possession of his BMW key fob, which was in his pocket. And I believe it was in her glove compartment next to the handgun that the victim allegedly saw, arguably trying to permanently deprive him of it, as that key fob was in her vehicle within the glove compartment. So state has to prove that she took property from the victim. In this case, she took a BMW key fob, a wallet, a phone, as well as his chain. She has to permanently or temporarily deprive him of it. She arguably at least temporarily deprived him of it, because when he said that he was calling law enforcement is when she started to try to pick up the belongings to hide the evidence. The property was of some value. Arguably, the BMW key is of some value. His wallet and the items within his wallet are of value. The chain is of value. And it was by force, violence, assault, or putting him in fear during the course of the taking. She had a firearm with him and was battering him. So it's by force due to having just the firearm within his presence, coupled with the statement of, I got something for you, I'm going to kill you. The firearm was still on her person while all these takings were occurring. And it was by violence or assault, as she was going within his pockets, taking things off his person. So the state would contend that there is enough for a robbery with a firearm. The firearm doesn't have to be directly pointed at the victim the entire time during the course of the taking.
All right, go ahead, Ms. George.
My argument is, again, the taking has to be by force. I'm not arguing any of the other elements. Again, they're in the midst of a scuffle. This is from the victim. The victim states he slaps the firearm, they begin to fight, and that's when, in the midst of the fight, that the chain's ripped off. They're still fighting. She's pulling things out of his pocket, throwing him in the road. I would argue that this is not a situation where my client is coming up to rob the alleged victim of his property. This is a domestic violence dispute. The firearm, yes, there is the battery, the aggravated assault, the tampering with the witness by throwing the phone, but her intent was never to go up and forcibly rob him. That's not the purpose of this statute, robbery with a firearm. This is domestic dispute. She's in the midst of fighting. She's ripping things off of him, pulling things out, throwing them in the road. Your Honor, so I would just ask that based on the four corners of this arrest affidavit, there is no taking by force.
Your Honor, intent is not one of the elements state has to prove. And state still contends that it's by force that she even got a firearm from her vehicle and came back at him before she started attacking him and taking things from his person.
Yeah, and she didn't say, hey, give me your items. She stated, I'm going to kill you. There's a difference between a robbery with a firearm. That's the purpose of robbery. I'm going to take your items by force, i.e. the firearm or however else, any other weapon that you may have in your hand. Here, he slaps the weapon from out of her hand, so it falls to her side. And they're fighting, and the victim states in the midst of the fight, she's pulling and the chain gets ripped off.
Your Honor, one, she does not have to say, give me all your things, this is a robbery. That's, again, not what the statute nor the Florida jury instructions say. And in regards to counsel saying that's when the fight occurred, the affidavit says that's when she started attacking him. So I don't believe there was a fight. Law enforcement writes that's when she began attacking him. There wasn't a fight that the victim agreed to or got engaged in. She started attacking him, grabbing things off of his actual person.
All right, so I'm reading the affidavit. And if you look at, so the first statement they have is from the defendant, and then the second statement is from the victim. Somehow she ends up where he is. They disagree about that because he says he told her not to come. She says they agreed to meet. She says when she arrived, he's holding a firearm. That's when she goes back to get hers. He doesn't say anything about him holding a firearm.
Nor does law enforcement find a firearm, Your Honor.
But when she approaches him with her firearm is when he slaps it to get it not pointing at him, and then that's when they fight. In the midst of the fight is when she yanks the chain, the wallet, which she throws on the ground. All right, and then the statute says, 812.13, robbery means the taking of money or other property, which may be the subject of larceny, from the person or custody of another with intent to permanently or temporarily deprive the person or the owner of the money or other property, when in the course of the taking there is the use of force, violence, assault, or putting in fear. And then 2A, if in the course of committing the robbery, the offender carried a firearm or other deadly weapon. So let's look at these elements. What we have is the taking of money or other property. Is there anything in the jury instruction that defines taking?
In the course of taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events.
So there's no definition of taking. All right, so the taking of money or other property, which may be the subject of larceny, from the person or custody of another. So the state's contention is yanking the chain and the wallet and the key
And the
fob
phone and
is
the key
taking.
fob.
All right. With intent to either permanently or temporarily deprive the person or the owner of the money. So,
Again, my contention for those is she temporarily deprived him of the phone,
wait,
the wallet.
wait, back up. Show me where in the affidavit it says she intended to permanently or temporarily deprive him of the property. Point me to that.
Your Honor, when she
has to
throws it
intend.
across the street.
So
She throws it across the street and then she puts the BMW key fob in her car in the glove compartment. And he testified that she does not have his key fob and shouldn't have it, and the law enforcement clicked it and his car lit up.
she might have it there. The BMW key fob is found in her car.
Her car in the glove compartment. Next to the gun.
I was wavering as to the chain and the wallet, but I think the fact, hold on, point me to that in the affidavit.
It is pretty much the last paragraph, Your Honor. She starts picking up his belongings from his wallet in the roadway because she's trying to hide evidence. I detained Valerie in handcuffs. That last paragraph is when
I
they
see.
find the gun and the key fob.
Next to the handgun is the BMW key fob, which he presses the unlock and it unlocks the victim's BMW.
And just for the court's consideration, Your Honor, this is, again, a domestic violence incident. My client and the alleged victim have been in a relationship. She always carried a spare key, so to his vehicle. So I just ask that you take that into consideration.
That's not within the four corners of this affidavit, Your Honor. And the victim testified otherwise.
Yeah, it was a great argument and you almost won, Counselor, but I think the fact that the key fob is found in her vehicle and in the affidavit it says that she took it during the course of this incident, I think that's probable cause. So I do find there's probable cause for these charges. Does the state wish to be heard on bond?
Yes, Your Honor. State would ask for a reasonable bond as to 1, 3, and 4, as she's otherwise entitled to do it. Given that count 2, robbery with a firearm, is a life offense, state is asking that you hold her no bond pending an Arthur hearing downtown.
And Your Honor, I just ask that you consider the facts of this case. Again, if you look at my client's history, she has 0 convictions, 0 failures to appear. Again, I think this is a domestic violence dispute.
However, she does have an arrest of an armed burglary of a dwelling.
Your Honor, I'd ask, again, there was no conviction. So I'd ask you to take all of that into consideration. And in this unique situation, I would ask that you set a bond on the robbery.
And council knows that I am loath to do that. However,
Your Honor, I'm just,
hold
again,
on. However,
concerned.
I do think this is a pretty unique circumstance. I need to hear about this arrest for armed burglary of a dwelling. When did it occur? Why hasn't a charge been filed?
In Orange County, I have a 2018 non-arrest misdemeanor petty theft that we did not go forward on.
No.
I have a 2004 felony 65. Cannabis with intent to sell and deliver, possession of a firearm by convicted felon, possession of a firearm by convicted felon. That was a withhold of adjudication. She got 18 months supervised probation.
When was that?
No, she said that's not her.
Well, she has no prior felony, so how could she have a possession of a firearm by a convicted felon?
I have Valerie A. Griffin, 1965.
Someone else. That's not her.
The only one I want to know about is this armed burglary of a dwelling. But you don't, maybe it wasn't in Orange County.
I'm checking CCIS, Your Honor. Griffin. Red light, red light, red light.
Also, Ms. George, does the court have discretion to set a bond on a punishable by life offense?
Yes, you do, Your Honor.
Your Honor, the armed burglary happened.
1992?
Yeah, September 3rd, 1992 in Orange County, it was sealed.
It was what?
Sealed.
Oh.
Your Honor, it's still a prior firearm offense with a new firearm offense. And from the victim's testimony, he told her not to come. She comes anyway.
My client stated she did not have a firearm.
Returns to her vehicle.
In the armed burglary, she stated there was no firearm.
It was fighting.
She stated it was a fight.
All right, here's what I'm going to do. Your bond on count 1 is $100. Count 3, it's $5,000. Count 4, it's $1,000. Count 2, because it's a punishable by life offense, you are not entitled to bond at this time. I understand the state is objecting to the court setting any bond prior to a full Arthur hearing.
Your Honor, if you're inclined to otherwise set bond, state would ask for a high bond, given that it is a F1 punishable by life. And given we don't have victim testimony here today, and given that there is PC for the charge.
There is PC. I am going to set bond at $150,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't return to his residence for any reason or be within 1,000 feet of his residence or place of employment. Do you understand that?
Yes, ma'am.
All right, good luck. Y'all, we're not even out of the felonies. Please tell me your name.
Erica Johnson.
21 CF 13083. You're here charged with aggravated assault with a battery, aggravated battery on a pregnant person, criminal mischief, battery domestic violence, tampering with a witness to hinder communication to law enforcement, threatening a public servant, resisting without violence, and attempted battery. I'm going to appoint an attorney to represent you in this case. Ms. George, did you wish to be heard?
No, Your Honor.
All right, I agree. There is probable cause here for all of these charges. One moment. Your bond on count 1 is $1,000, count 2 is $5,000, count 3 is $1,000, count 4 is $1,000, count 5 is $5,000, count 6 is $5,000, count 7 is $1,000, and count 8 is $1,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You cannot return to the victim, any victim's residence or place of employment, or be within 500 feet of that. Do you understand?
Yes.
You can't possess or consume any alcoholic beverages or controlled substances without a valid prescription. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Sir, please tell me your name.
Cyrus Michael Joseph.
21 CF 13095. You're here charged with aggravated assault with a deadly weapon, domestic violence, and aggravated battery, great bodily harm, domestic violence. I'm going to appoint an attorney to represent you. Ms. George?
Yes, Your Honor. I would argue no PCS to the aggravated battery. In order to have an aggravated battery, great bodily harm, the injury must be, great bodily harm means more than slight, trivial, minor, moderate, and does not include mere bruising. Here in this arrest affidavit, it just states that there was a bite mark on the temple. There is a, I think it's a laceration, small laceration scratch on the chest, and a bite mark on the temple. I believe there was a lump. But other than that, there is no indication that the bite mark tore through the skin, that the alleged victim needed to go to the hospital or anything to that effect. So I would just argue that there is no PC for an aggravated battery, great bodily harm.
All right, what says the state?
Your Honor, I couldn't find any case law regarding bite marks and how they relate to great bodily harm if a bite is sufficient. However, state would just contend that a bite on your temple is a kind of a rare breed. Your temple is on your head and a very delicate part of your head where there is a bite mark. I understand counsel's argument that there isn't note of if there was puncture marks or anything like that. But given the location of the bite mark, state would contend that that is enough. That's not slight or trivial. In conjunction with a lump on the forehead, other lacerations and other scratches on her person, state would just argue that a bite on a temple, given the location, is enough for a great bodily harm.
Ms. George, any response?
Your Honor, I would argue it is not. Again, the statute states it must be more than slight, more than moderate. Essentially, a great bodily harm needs to be severe. Again, in the four corners of the arrest affidavit, there is no mention of tearing through the skin. There is no mention of permanent disfigurement. There is no mention of going to the ER, seeking medical attention. I would argue there is no PC for great bodily harm.
Your Honor, if you're not inclined to find PC, state would ask for 24 hours.
All right, I'll give you 24 hours. There is probable cause as to count 1. And there is probable cause for battery.
Yes.
I'll give the state 24 hours. All right, we'll see you back here tomorrow, sir. Please tell me your name.
Olivia Koshy.
21 CF 13089. You're here charged with aggravated battery with a weapon, dating violence, battery, dating violence, and possession of cannabis with intent to sell or deliver. I'm going to appoint an attorney to represent you.
Your Honor, in regards to count 3, I don't believe there's any intent to sell or deliver within the affidavit. It just states that green leafy substance was found in her coin pocket, just 2 plastic baggies, and then the other baggie contained a crystal-like substance. and it's going to be sent to FDLE. She wasn't in contact with anyone to sell. She didn't have any indicia of sale. She just had possession of the cannabis.
Other than her statement that she sells it, she doesn't use it?
It's my understanding from the case law that
That's not enough?
that's not enough.
If the defendant says, I sell this, that's not enough?
Your Honor can still find PC. It's your determination, but that was my understanding.
Do you have this case law?
I do not. Not readily available.
I assume the defense agrees
Yes, Your
with
Honor.
the state?
Yes, Your Honor.
I don't know the answer, but there is no other indicia of sale. But if the defendant says, I sell it, that seems like that'd be pretty good indicia of sale, no?
Your Honor, it's your PC determination, and I didn't present case law. That was just my understanding. But Your Honor can still find PC over my understanding of the law.
All right, I'm finding probable cause as to count 1, 2, and possession of cannabis for count 3. Do you have the statute, Ms. May?
1 second, Your Honor.
Okay.
And while we wait, Your Honor, I'll just make the argument for her out on bond. I just ask that you consider if you're going to revoke, you revoke in double as opposed to holding her in no bond. It looks like her last conviction was in 2016, and it appears she was in pretrial diversion for that charge. So I just ask that you take that into consideration before revoking and holding her in no bond. If I'm not mistaken, I thought she was she cooperated with police officers, Your Honor. So I just ask that you also consider that.
Possession of cannabis 20 or less is 893.13 sub 6 sub B, as in boy.
What? One more time?
It is 893.13 sub 6 sub B.
All right, your bond on count 1 is $2,000, count 2 is $100, count 3 is $100. You can have no contact with a victim or witness. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition.
Your Honor, may I have 1 second to look up that out on bond?
Yes.
Municipal ordinance, so it's not within our system.
Yes.
But a disorderly conduct could potentially be fighting, which if it was, state would ask that you revoke.
You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You cannot have contact with the witness in this case. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Just a moment.
Your Honor, in regards to 20 MO 300, I did pull the affidavit. It occurred March 6th. It is alleged that she was told multiple times to stop yelling. She continued to yell and walk away from officers with a male subject. The officers then observed her attempt to hit the male with her left hand, slightly missing.
All right, at this time, I'm revoking your out on bond case. Good luck, ma'am. No, you don't have a bond on that. Your attorney has to file a motion to get bond on that case.
So, but right now I have no bond for anything?
No, you have bond on the new case, but even if you post it, you can't be released until your attorney files a motion in front of the trial judge on the old case.
On the old case,
The disorderly conduct. I revoked your bond.
oh, because I was supposed to pay my fine today, that's why, but.
You're going to have to talk to your attorney about it. Good luck.
I just bailed out and then I can wait.
Wait, come back. I can't hear you.
So they'll be able to bail me out and then I'll have to speak to my attorney?
No, you can't leave today, even if you post the bond, because I revoked your bond and you're out on bond case. So you need to talk to your attorney right away so they can file a new bond motion in front of your trial judge.
What would that be?
That's up to you and your attorney. Yes, ma'am. Good luck.
Crawford, Sean, medical.
21 MM 7029. I'm going to appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
All right, there is probable cause. Hold on one moment. Bond is $5,000. No victim contact, no weapons, firearms, or ammunition. Cannot return to Universal Studios. Must maintain a separate residence. I'll allow a one-time return with law enforcement to gather his belongings. No contact with any witness in the case. Cannot possess or consume any alcoholic beverages. All right. Please tell me your name.
Marcus Damos.
21 MM 461. You're here charged with battery. I'm going to appoint an attorney to represent you. There is probable cause here. One moment. Is he on probation right now?
He is.
So is there a hold for a violation of probation?
It is.
All right. Sir, your bond in this case is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. And I'll allow a one-time return with law enforcement to gather your belongings. I show that you're a violent felony offender of special concern and you're currently on state probation. So at this time, even if you post your bond, you won't be released. There's a hold for you for a few days because there might be a violation of probation warrant that's filed. I can't tell you if there will be yet.
Your Honor, I believe the victim is also a minor.
Yeah, I saw that. So good luck, sir. Call your attorney right away. Please tell me your name.
Michael Dwayne Grady Jr.
21 MM 7022. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Ma'am, do you wish to testify?
Yes.
Please raise your right hand to be sworn. Sir, you look at me.
Please swear to tell the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Please state your name for the record and spell your last name.
Desiree Lloyd, Loyd.
This prosecutor is going to ask you some questions.
Good morning, ma'am. Can you please state your relationship to Mr. Grady?
Boyfriend?
Are you afraid of him?
No.
If he were to be released from custody today, would you be afraid of him?
Yes.
Has anything like this ever happened before?
No.
Are you willing to call 911 if anything like this ever occurred in the future?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with him while this case is pending?
No.
Thank you. That's all I have, Your Honor.
Anything from the defense?
No, Your Honor.
Sir, you look at me.
Oh, I'm sorry. I didn't apologize.
Don't do that again. I saw what you did. You will have no contact with her. Do you understand that?
I understand.
That includes while you're in my courtroom. I am placing you on pretrial release and requiring that you post a monetary bond of $1,000. Do you understand what no contact means?
Yes, ma'am, I do.
You cannot speak to her. You cannot shake your head at her. You cannot send a text message to her. You cannot send a message through friends or family. You cannot speak to her on social media. Is that clear?
Understand. I do have a question.
we share a lot of things together since we are in a relationship for like 7 years. So with our timeshare, our vehicles and all that stuff, how does that really?
So you can have no contact with her. I'm going to order that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate it with her.
No, I know that. I've talked to law enforcement. I'm just speaking of like my timeshare and all the other stuff, like stuff that we have, both of our names on it.
So you just can't be there when she's there, but you can't talk to her to find out when she's going to be there.
I know, that's what I'm saying, because with our timeshare is in Mexico. So with that being said, a lot of our stuff together, we have to be there together to sign papers together. So that's why I'm asking that.
You're going to have to talk to your attorney about that. I can't give you legal advice.
Yeah, because I mean, if that's the case, then I don't know how that's going to happen. Because then it's going to be a violation every time we have to sign papers for the timeshare.
Right, you cannot do that.
That's what I'm saying, but it's money. We can't lose all that money, and then that's going to go against our how do you say, our credit score and stuff like that. So that's why I'm saying we have a lot of financial obligations together with both of our names on it.
That's something you're going to have to talk to your attorney about, because you can have no contact with her for any reason.
Okay, and as far as like her mail goes, she can't come to the house that is on her ID, because we have the same IDs, correct?
No, she can go anywhere she wants.
No, but the separate residence that I'm going to be staying at is where her mail goes to. So that means she cannot come to that residence, period.
No, it doesn't. This court does not have jurisdiction to order her to do anything. I only have jurisdiction to order you to do
So
things.
if I'm at that residence, she still can come there? Isn't that a violation of me?
You're the one who's at risk of being violated, not her.
That's what I'm saying. So if she comes to that residence, am I supposed to call the police so I don't violate?
I mean, if I were you, I'd go out the back door.
That's my mother's house. She's not coming to my mother's house. So no.
I can't give you legal advice. What I can tell you is, I can't order her to do anything. I can only order you.
Okay.
So if she comes to where you are and you choose not to leave, and someone calls law enforcement and they find you together, you're the one who can be arrested and held at no bond, not her.
So then that means once I get out, I have to put an injunction on her as well, basically.
I can't give you legal advice.
I've been here before, so I know. That's why I'm just making sure.
All right, good luck, sir.
Thank you, ma'am.
Thank you, ma'am. Good luck. Please tell me your name.
Daquan Gomes.
21MM7021. You're here charged with battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Just making sure there's not a victim in this case or a witness.
No, Your Honor.
All right, thank you. Does the state object to pretrial release?
Your Honor, given that there was also property damage, they would ask for bond with pretrial release, including, I believe, front window.
I'm going to place you on pretrial release and require that you post a monetary bond of $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, Judge.
Thank you. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. You can't have any unsupervised contact with any minor child under the age of 18. All right, good luck, sir. Yes, sir. Please tell me your name.
Leonard Jackson.
21MM237, you're here charged with battery. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Oh, no, Your Honor, he had a question.
Okay.
Thank you, Your Honor.
All right, sir, there is probable cause here. Does this, go ahead.
I would ask for pretrial release, Your Honor, in this case. It appears he's a military vet. He's been here in Maitland for over a year. But he's employed full-time, so I'd ask for pretrial release in this case. 0 failures to appear.
Does the state have any objection?
Your Honor, he does have a BAT DV from 2011 that the victim was unwilling to prosecute. It was the same victim, Miss Wilson, so state would ask for bond with pretrial release.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that significantly to $100. With special condition, I'm sorry, go ahead.
Yeah, thank you.
Yes, sir. With special conditions, you can have no contact with the victim. Do you understand what that means?
I need to go and get some clothes though.
I'll allow a one-time return with law enforcement, but I'm ordering that you must maintain a separate residence. You can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages. You'll be subject to random alcohol screens. Any other conditions?
No, Your Honor.
And thank you for your service, sir. Good luck. Sir, please tell me your name. 21MM7031. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause.
Your Honor, he qualifies for pretrial.
Does the state object to pretrial release?
No, Your Honor.
I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what that means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
Yes, ma'am.
And you can have no unsupervised contact with any minor child under the age of 18. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Does that include my two children I have and my ex-wife that I have 50-50 custody of? Or that just includes my child that I have with her? As far as the unsupervised visits?
Hold on. Give me one moment. It would include all children if I stay that order. So let me read this again.
Your Honor, state would ask that it be all children, given the allegations within the affidavit.
Yeah, that's what I was reviewing. All right, yes, it does include all children under the age of 18. You have to have supervised visitation, and I'm going to order that you must comply with any plans set in place by DCF. Good luck, sir.
Yeah, I don't know if she'll accept the Guzman one, though. Yeah.
All right, it is 1:31 PM. We're back on the record. We have Spanish first.
Yes, ma'am.
Good afternoon, Your Honor. This is Rafael Burris, State Certified Court Interpreter. I have been previously sworn.
Good afternoon. If you could please connect with the headset.
Certainly, Your Honor. Allow me just a moment, please.
Yes.
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Thank you. Sir, please tell me your name.
Valentin Guzman-Perez.
Valentin Guzman-Perez.
21MO1143. Sir, you're here charged with open container of an alcoholic beverage and violating state misdemeanors. There is probable cause. Was there an offer?
Yes, Your Honor. I've been authorized on the city's behalf to offer a withhold credit time served. I didn't know if Your Honor would be inclined to take it As the state misdemeanors, looks like it was a resisting without violence, almost assault with almost.
I think it's assault on a law enforcement officer.
I don't believe that's what the law enforcement officer charged the state misdemeanors as, even though that's alleged facts show. I am willing to resolve the case with a withhold and great time served, if Your Honor would take it.
I will not. Did you have a chance to speak with him before court, Ms. George?
No, he's Spanish, Your Honor.
I would adjudicate him guilty on this charge if he wants to enter a plea today. Did you give him the
There's
plea form in Spanish?
Yes, Your Honor.
All right, Mr. Guzman-Perez, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth to help you God?
Sí.
Yes.
Sir, did you have a chance, put your hand down. Did you have a chance to read that form that's in front of you?
Sí.
Yes.
So you understand the rights you'd be giving up if you enter a plea of guilty or no contest today?
Sí.
Yes.
Do you have any questions for me about the rights you'd be giving up?
No.
No.
All right, sir, you understand you can enter a plea of not guilty, guilty, or no contest today? Do you know how you wish to plead to these charges?
Culpable.
Guilty.
You understand that if you're not a U.S. citizen and you enter a plea of guilty today, you can be deported.
Comprendo.
I understand.
You understand if you're on probation anywhere, this plea could violate that.
Comprendo.
I understand.
Sir, are you under the influence of any drugs or alcohol today?
No.
No.
All right, at this time, how do you wish to plead to open container of alcoholic beverage and violating state misdemeanors?
Culpable.
Guilty.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. Good luck, sir. You have 30 days to appeal in writing.
Gracias.
Thank you.
Oh, that's it for interpreter cases at this time. Thank you.
Thank you, Your Honor. Have a good afternoon.
You as well. Please tell me your name.
Renee Burgos.
21 663.
Can I say something, miss?
One moment. Sir, you can say anything you want. Everything you say is being recorded and can be used against you later. Do you understand?
I do understand. I turned myself into jail because they were trying to kill me. So the smartest thing I thought was I told the cab.
I would advise you not talk about facts.
All I gotta do is pay the cab driver. It's me against the cab driver. I chose not to pay him to come to jail to protect my life because you have guys out there with guns, and I wanted to be safe. I was going towards my mom's house. I know they were chasing me. All I gotta do is pay the cab driver. He drops the case because that's all it is. I didn't pay the cab driver. I chose to come to jail. I promise you, to save my life.
Who's chasing you?
Some dudes, that they're from my area. You know what I'm saying? And
What area?
I live in Richmond Heights.
And where?
Richmond Heights.
Richmond Heights.
Yeah, towards like Colonial. So
Okay.
one cop said he could take me to expire, and then the other cop said, no, I'm taking him to jail. Like, so I could pay the cab, and the case is closed. I'm smarter than I look. But I chose to come here, yes. So it doesn't matter if you're recording it because I chose to come here. If I pay him, case is closed. Does it make sense? It's me against a cab driver. I pay him $100. He's gonna, I ain't going to court. And then it's a waste of time. Your time, my time, the government's time. And I was supposed to go to work. They haven't, look how they got me. I was supposed to go to work today. I have a job working for the NASA that we do the booths. That I built these. And I'm supposed to work $16.50 an hour. I have a felony record. It's hard for me to get a job. So they're not letting me bond out. So they want me to be a crazy guy in jail with a petty theft. I'm gonna get out anyway, but then I lose my job.
Sir, your bond was $250.
I know, but they didn't let me bond. 'Cause I was calling last night. I mean, when I got here, and they the bondsmen are not answering the phone. It was late night.
Oh. All right, well,
Your Honor, he does have a very lengthy petty theft history.
unfortunately, at this point, it's the state of Florida versus you, not the cab driver versus you.
I know.
So,
So make me a criminal, even though I'm admitting that I was in danger, right? So
well, it sounds like you think you might have some defenses to this charge. I'm going to appoint an attorney to represent you. Based on the affidavit, there's probable cause.
yeah,
However,
I'm admitting that I didn't pay the cab, but all I had to do was pay him.
right,
I did that.
I understand what you're saying.
The state's just gonna, well, do what?
I don't know. That's up to the state.
With me and the cab driver.
So I don't know. That's up to the state of Florida.
Oh my God. Maybe I need to move from Florida. How about that? Because I'm tired of being in this system. Y'all just want me in jail?
You can do that. Each state has their own criminal justice system, and it'll be very similar. If you commit what they're saying is a crime, it'll be the state versus you.
Cop didn't want to arrest me, ma'am. I told him to take me in because they were trying to kill me. I'm not gonna let people kill me. I'm smarter than them. They're ignorant. And I don't mean black. They're just dumb. They dumb. So I used you guys to come here to be safe.
Okay.
Do you understand that part? That's why I want to talk to you.
I do, but what is it that you want me to do? You have a bond?
They don't let me use the bond phone. They think I'm crazy. I was a trustee. I'm the best trustee in this building. I've been here for years.
Oh. Why would they not let him use a phone? Does anyone
Because
know?
they're scared, because I have a New York attitude, the way I talk, like I'm talking to you now. And my grandma had a gun. My mom sleeps with a bat. There's evil people out there.
That's
You
true.
got the Chomos living in the woods, raping people because they have nowhere to go because they're a felony. You can't have nowhere to live. So where are we supposed to live, ma'am? I went with $3,000 to a complex. They don't want to rent me an apartment.
Well, I believe that.
That's not
All right, I'm going to stay your bond at $250 and just say that you're not allowed to return to the Wawa located at 13501 West Colonial Drive, and you can't have contact with any witness in the case. I'm appointing an attorney to represent you. But sir, your bond is $250, so you can post that. Anytime you post that, you'll be released.
You're not letting me use the phone, ma'am. Can you please tell them let me use the phone?
So I can't order them to do that. What I'm going to do is ask, can you make sure that, I don't know if there's a reason they're not letting him use the phone.
Your Honor, is that no contact with victims or witnesses or just witnesses?
Yes. I'm sorry, what? Yes.
Leon is mental health, Your Honor.
Yes. I'm sorry, go ahead, B.
Leon is mental health.
21 MM 1596. I'm going to appoint your office, Ms. George.
There was an offer. I'm not sure if do you think he can come tomorrow? Or
Who?
DeLeon? No? Okay. I'll wait the appearance room.
It's a capias with a $250 bond.
Okay.
And I'm taking no action on the out on bond.
Thank you, Your Honor.
Please tell me your name.
My name is Tim Real Battle.
Sir, you're here in 21 MM 6911, charged with criminal mischief. The public defender's already been appointed to represent you.
Yes, Your Honor, we're going to answer a plea of not guilty.
Division 83 pretrial conference is October 18th, 8:30 a.m., courtroom 60.
That's your next court date, sir.
Yes, is this a new charge or this is the same charge I done had? Yeah, y'all just arranging it?
So this is a criminal mischief charge, and it looks like it was remanded from circuit court down to county court. Is that correct, Ms. May?
Yes, Your Honor, it came in, the arrest was September 13th. It came in as an attempted burg structure, F3, and a criminal mischief. We ended up only filing the criminal mischief.
All right, so instead of filing the felony, the state's only filed the misdemeanor against you in this case.
They threw the felony out.
I'm sorry?
They threw the felony out.
Yes, sir, they did.
Okay.
So just get in touch with your attorney right away.
Yes, ma'am. Thank you.
Good luck, sir. I feel like I've seen him several times recently.
Your Honor, can we skip over Cruz?
Yes, sir.
Israel Jackson is medical.
21 MM 1481. Ms. George, your office already represents him.
I'll waive and enter a plea of not guilty, Your Honor.
Division 61, pretrial conference is November 15th, 9 a.m., courtroom 6B.
Royal Irvin, medical.
21 MO 1066. Ms. George, your office represents him as well.
I'll waive and enter a plea of not guilty, Your Honor.
Division 85, pretrial conference, October 18th, 9 a.m., courtroom 4A.
Shapley Mail.
21 MM 412. You're here charged with petty theft. Ms. George, your office represents him.
Yes, Your Honor, the state is offering a withhold of adjudication, credit time served, no return to Walmart located at 1700 South Orange Blossom Trail. I did speak to Mr. Shapley, as well as his attorney assigned to the case. He understands all the rights he will be given up and would like to accept the state's offer here today.
Ms. May, why would the court withhold adjudication in this case?
Your Honor, he has no prior petty theft history, and the history that I do see that he has, at least here in Orange County, it looks like all he previously has is a disorderly and a dwellis from 1996. So this is his first enhanceable offense, and first time he's being seen for a criminal offense other than the municipal ordinance of disorderly.
Isn't a driving while license suspended enhanceable?
Yes, Your Honor, but it was from 1996, so he pled guilty to that back then.
In this case, what did he allegedly steal?
In the instant case, it was, I believe at Walmart, he was ticket switching items and misscanned some items. I believe the total amount of theft was, total amount of misscanned items was $90.10. It was Gain laundry detergent, 2 things of ribeyes, a solar battery charger, linguine pasta, a super sub, and Alfredo sauce.
All right, sir, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you heard what your attorney said. Is that what you want to do here today?
Yes, ma'am.
You can put your hand down. You had an opportunity to speak with your attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
Just a stupid mistake.
I'm sorry?
It was just a stupid mistake I did.
I understand. All right, sir, you understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
And if you are on probation anywhere, this plea can violate that?
Yes, ma'am.
All right, sir, at this time, how do you wish to plead to the charge of petty theft?
A no contest, ma'am.
Also, the attorney explained to you petty theft is what we call enhanceable, which means that after so many convictions, the state can file it as a felony.
Yes, ma'am.
So you understand that?
Yes, ma'am. I learned my lesson today, ma'am.
And with all that in mind, you want to enter a plea of?
No contest, ma'am.
All right, thank you, sir. I'll accept your plea. I find it's freely and voluntarily made. I will withhold adjudication. I'll give you credit for the 25 days you've been in custody. I'm ordering that you pay court costs. I'll give you a year to pay those. You are not allowed to return to Walmart at the address listed by your attorney. Do you understand?
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
You have a blessed day.
You as well.
Douglas Bronson.
21 MM 7017. You're here charged with trespass on property after warning. Was there an offer?
Yes, Your Honor, the offer conveyed was an adjudication, credit time served, and no return.
And And I did speak to Mr. Bronson, went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today, Your Honor.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right. Sir, you had an opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No.
You understand if you're not a U.S. citizen, you can be deported?
Yes.
And if you are on probation anywhere, this plea could violate that probation?
Yes.
All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs, sir. I'll give you a year to pay them. And I'll order that you're not allowed to return to the Circle K at 6949 Silver Star Road. Good luck, sir. You have 30 days to appeal in writing.
Thank you.
Yes, sir.
Hello?
21 MM 665. You're here charged with petty theft. It says shoplifting. Petty theft from a merchant, second or subsequent offense. Was there an offer in this case?
No, Your Honor, as it's enhanceable.
Right. All right, sir, at this time, I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $500. You can't have contact with any witness or victim, and you can't return to 400 West Franklin Street, the Kangaroo Express there. Do you understand? Good luck, sir.
Zachary, Venel.
21 MM 7018, you're here charged with carrying a concealed weapon, resisting without violence, and wearing a mask, hood, or other device in public. Was there an offer in this case?
No, Your Honor, due to a firearm being involved.
All right. I'm going to appoint an attorney to represent you in this case. Give me one moment.
Your Honor, will ask for pretrial release in this case.
All right, there is probable cause.
He has 0 failures to appear. The only conviction I see is a trespass and loitering and prowling. It looks like he's been here for over a year. It appears to be a clown mask.
Your Honor, state has no objection to PTR.
All right, sir, I'm going to place you on pretrial release. With special conditions, you can't possess a weapon, firearm, or ammunition. Do you understand that?
Yes, ma'am.
I mean, he was riding a bicycle, so I don't see another.
No, Your Honor, I believe that's reasonable.
All right, good luck, sir.
Next one, Tyson.
21 MM 951. Sir, you're here because a capias was issued for your arrest for failing to appear on charges of trespass in structure, trespass on property other than a structure, and criminal mischief. Your bond is $150 on count 1, $100 on counts 2 and 3. I'm going to appoint an attorney to represent you in this case, and I'll take no action on your out on bond case. Good luck, sir.
So what?
I'm sorry?
You can bond. You can post bond.
You can post bond. There's bond authorized on the capias.
On what charges? I thought I only had one charge.
It's 3 charges. It's,
I was already locked up for this case.
right, but then you had a court date, and a judge issued a capias saying that you failed to appear for court.
For only trespassing, right?
Hold on one second, let me look at the capias.
It originally came in as a trespass, Your Honor. We ended up filing.
I was already, and I did time for this already.
I think the state filed different charges. It's trespass in structure, trespass on property other than a structure or conveyance, and criminal mischief, less than $200. So there's actually 3 charges in that same case. That's what the state filed. And it says you failed to appear for a status hearing on August 12th, 2021.
August 12th, which was the mail, I was already out on this charge, And it got sent to the address that I.
Don't talk about do not talk about the facts of the case.
So here's the thing, because it's a capias that was signed by another judge, I cannot change it. But if you have a defense, like for instance, if you were in custody at the time, so you didn't willfully fail to appear, you want to talk to your attorney about that.
I can't go on that. I'm homeless.
Sir, I can't change another judge's capias. So call your attorney and ask them to file a motion in front of that trial judge.
So.
Good luck.
And tape. Vicente Perez, bonded.
Okay.
Shaquin Orlando, bonded.
Madoche Saint Armand.
21 CF 13086. You're here charged with burglary of a structure, grand theft, and resisting without violence. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Not for PC purposes, Your Honor.
All right. I agree. There is probable cause here.
Your Honor, I would just ask that you consider reducing the bond amount on the burglary of a structure. My client is currently unemployed. He stated he can't afford to post the bond as is, so I just ask that you consider reducing it a little. It looks like he's been in the Orlando area for over a year, but I do see he has 2 photos here, but that last one was in 2018.
Was he released from DOC August 30th of this year? All right, I will not reduce it on count 1, but I will treat counts 2 and 3 as subsidiaries. So it'll be $3,500 on count 1, $150 on count 2, and only $100 on count 3. With special conditions, you can have no contact with any victim or witness, so you cannot return to Evans High School. Do you understand?
Yes, ma'am.
All right, that's all. Good luck.
Your Honor, state would ask for no weapons, firearms, or ammunition.
Oh, come back.
Come back.
Sorry. The state asked for me to add a condition, and I will do that. You're not allowed to possess a weapon, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Chat car.
21 CT 1716, you're here charged with driving while license suspended. And 21 CF 13084, you're charged with trafficking in cocaine greater than 28 grams but less than 200, possession of alprazolam, and resisting without violence. At this time, I'll appoint an attorney to represent you in both of your cases. Did you wish to be heard, counselor?
Your Honor, for the trafficking, I'm not sure it matters, but it looks like they found them in different areas.
It can be aggregated.
It can be.
Then that's, no, I don't have any of them.
All right. I didn't think there was an argument there, but I just wanted to make sure before I...
That was the only thing that I saw, Your Honor, but I don't have any arguments.
I agree. I don't think there's an argument here. There is probable cause for your arrest. I'm going to treat the CT as a subsidiary. That bond is $100. It'll be $50,000 on count 1, $150 on count 2, and $100 on count 3. You're not allowed to possess or consume any controlled substances without a valid prescription. Do you understand? Yes, ma'am. You can't have contact with any known drug dealers. Sir, you cannot drive without a valid Florida license. Do you understand? Yes, ma'am. Good luck.
I'm sorry, Your Honor, what was the bond for the driving?
I treat it as subsidiary, so it's $100.
Thank you.
Frederick, bonded.
Jason Graham.
21 CF 13093. You're here charged with possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
Sir, I show that you're on probation and that you have a hold out of Lake County. I don't have any other details about that, but I just want to make you aware that that hold exists.
Okay.
So I don't know if I'll see a warrant. I don't know if you're coming back to see us in the next couple of days, but I just want you to know that.
Okay.
So make sure, call your attorney right away.
There was a warrant, that's why they moved me over.
I think so too, or it might be pending. There might be one that's coming. So if there is and they serve it on you in the next couple days, you'll come back here. I just want to make you aware that it's there. All right, good luck, sir.
State your name.
Is this Dean Henry, ma'am? This is Dean Henry.
21 MO 1145, you're charged with open container of an alcoholic beverage. 21 CF 13078, you're charged with possession of cocaine with intent to sell or deliver and possession of cocaine. I'm appointing an attorney to represent you in both cases. Ms. George, did you wish to be heard?
Yes, Your Honor, as far as the possession of cocaine with intent to sell or deliver, I would argue no PC. There were no scales found, there were no individual baggies. It seems that they found everything in one clear baggie. And they noted $39 in ones and $5 and a single $20. However, I will argue that's not enough to charge my client with possession of cocaine with intent to sell or deliver.
What says the state?
Your Honor, state's only argument is he did have a large possession of small denominations, but also there were 45 rocks that were all similarly cut and concealed in a manner that law enforcement deemed to be common with narcotic sales. So state would contend that there is PC just based on the amount of rocks and that they're all similarly cut. It'd be more than personal use being 45 individual rocks.
That is a lot.
It is.
But does either party have any case law about this? Because I seem to recall, we've had this discussion several times. I recall that there is case law that says purely amount isn't sufficient unless it would be, a trafficking weight, but we don't have that. 45 is a lot. And I see that it's similar cut similarly in weight and shape. That seems to suggest it could be for sale, but I don't know if there's case law that gives us more direction on whether that's sufficient for intent to sell. I'm gonna look at the statute as well.
Your Honor, I have a case. It kind of sways both ways for PC and for without PC. It is from the 4th DCA from 2005. Arguably, it holds, while considering the type of circumstantial proof necessary to prove intent to sell, quantity and value may be sufficient when the quantity is substantial. However, in cases where small amounts of narcotics are found, courts require other proof of suspicious circumstances, drug paraphernalia, and other evidence which circumstantially would indicate an intent to sell. In this case, the defendant possessed 20 cocaine rocks and $114 in cash, and that was not sufficient. I don't know if double that would be sufficient. 45 rocks.
It was only 4 grams though, Your Honor.
Wait, I couldn't hear you, Ms. George.
I believe it weighed 4 grams.
But 0.1 gram is a hit.
So I found one from 4th District Court of Appeals 2008 case that stated the sole evidence presented by the state and testimony of the officer was that they saw the defendant drop a baggie containing 17 smaller baggies of cocaine in a bush. He did not see the defendant talk to anyone or do anything that would suggest an intent to sell, and that was not sufficient enough to charge the defendant with intent to sell. And I believe the quantity was 8.3 grams of cocaine in 17 smaller bags.
And that's out of the 4th DCA, what year?
2008.
Any negative treatment?
No, Your Honor.
I also have one that backs that proposition up some. It's a 4th DCA from 2011. The defendant possessed nearly 50 cocaine rocks, no paraphernalia. Officer's opinion that the rocks were for sale for others, that was insufficient to establish intent to sell within 1,000 feet of apart. They were not individually packaged. There was no evidence that the defendant was carrying any money. Officer did not observe the defendant attempting to sell. That was 50 cocaine rocks with officer knowledge of, I think they're for sale. That was not sufficient. That was 4th DCA from 2011, Harris v. State.
No negative treatment?
No, Your Honor, none. So I do not believe we have PC here for the intent based off the 45 rocks alone.
Yeah, I'm not sure that's PC, so I find there is probable cause for possession of cocaine. So what I'm going to do is set your bond on count 1 at $1,000.
Okay.
I'm going to ROR you on count 2. And your bond on the misdemeanor is $250. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You can't possess or consume any alcoholic beverages. You also can't have contact with any known drug dealers.
Okay, thank you, ma'am.
Yes, sir. Good luck.
Appreciate you.
No, I found PC for possession of cocaine on count 1.
Michael Lynn.
Yeah. 21 CF 13091. You're here charged with grand theft of a motor vehicle and battery. 21 MM 3244. A capias was issued for your arrest for failing to appear on a charge of trespass and structure. Your bond on that is $250. I'm going to appoint an attorney to represent you in both of these cases. One moment. There is probable cause. Your bond is $3,000 on count 1, $100 on count 2. You can have no contact with the victim or any witness in this case. Do you understand? You cannot return to Circle K at 14990 West Colonial Drive. You cannot possess a weapon of any kind, firearm or ammunition. All right, good luck, sir.
Outlaw, bonded.
Good afternoon, Your Honor. My name is Sean Pericles.
Good afternoon. Sir, you're here in 21 CF 3710. A capias was issued for your arrest for failing to appear on 4 charges. Your bonds authorized are $2,000 on count 1, $250 on count 2, $100 on counts 3 and 4. You're already represented by the Regional Conflict Counsel, but she could not appear here today. Your attorney told my office that she couldn't appear here. But it is a capias and you already have bond, which I can't change. So she's aware that you had this hearing today.
Yes, ma'am.
I also show that you're a violent felony offender of special concern who's on probation. I I can't tell you if there's a warrant for violating probation.
Oh, I could, ma'am, all right, see, let me help you with that.
Wait. Before you say anything else, you don't have to.
Okay,
And everything you say is being recorded and can be used against you later.
that is okay.
But since your attorney is not here, you don't have the opportunity to speak with her before you say anything.
Okay.
You don't have to explain the probation to me. I just want to make sure that you know that it's there in case a warrant is coming. I just didn't want you to be surprised.
Yeah, because when on the day of my release, which was May 9th, I had 48 hours to return to the probation parole office, which was on that weekend, so I was unavailable to go, and which led to May 12th, the day of this court date that I was unaware about. So I had to go and sign up for probation parole and like get inside the system on the day of my court date. So that's kind of what led me to not appear of my court date.